Tabling of documents. Déclaration.
Statements by ministers.
Reports from interparliamentary delegations. Presenting reports from committees, l'honorable.
The Honourable Member for Vaudreuil-Soulanges. Thank you, Mr. Speaker. I have the honour of presenting in both official languages the 9th report of the Standing Committee on Transport, Infrastructure and Communities entitled Addressing Labour Shortages in the Canadian Transportation Sector. Pursuant to Standing Order 109, the committee is requesting a government response. And I would like to add, Madam Speaker, that I'd like to thank all my honourable colleagues for their exceptional work, as well as the clerk and the analysts. Thank you.
Committees, the Honourable Member for Coquitlam, Port Coquitlam.
Madam Speaker, I have the honour to present in both official languages the 7th report of the Standing Committee on Public Safety and National Security, entitled Up to the Task, Strengthening Canada's Security Posture in Relation to Russia. Pursuant to Standing Order 109, the committee requests that the government table a comprehensive response to this report. Thank you, Madam Speaker.
Presenting reports from committees, présentation de rapport de comité.
Presenting reports from committees, the Honourable Member for Louis-Hébert. Thank you, Madam Speaker. I have the honour of presenting in both official languages the 9th report of the Standing Committee on Industry and Technology concerning Bill C-244, an act to amend the Copyright Act. The committee has studied the bill and, pursuant to Standing Order 9713, is requesting an extension of time. Thank you.
Conformément à l'article 80.
Pursuant to Standing Order 9713A, a motion to concur in the report is deemed moved, the question deemed put, and a recorded division deemed demanded and deferred. Pursuant to order made on Thursday, June 23, 2022, the recorded division stands deferred until Wednesday, March 8, 2023, at the expiry of the time provided for oral questions.
Introduction of private members' bills. Première lecture de
First reading of Senate public bills.
Motions. Présentation de
Presenting petitions.
the Honourable Member for Winnipeg North.
Madam Speaker, I'm rising on behalf of my friend and our late colleague, Jim Carr, to table a petition on behalf of the residents and staff of Shaftesbury Park Retirement Home in Winnipeg South Centre. Madam Speaker, the petitioners wish to bring to the attention of the House the 94 calls to action recommended by the Truth and Reconciliation Commission. The petitioners are urging the government to accelerate their implementation and are specifically noting Call to Action 8, which calls on the government to eliminate the discrepancy in educational funding for reserve schools. They are also asking for this recommendation to be implemented as soon as possible. Thank you, Madam Speaker.
Presenting petitions, the Honourable Member for somewhere here. Oakville North.
Thank you, Madam Speaker. It gives me great pleasure to present a petition to this House from constituents who are concerned about the proposed route and construction of Highway 13 in the province of Ontario. They've outlined a number of concerns with regard to the elimination of farmland, greenbelt, and wetlands, the impact on greenhouse gas emissions, the impact on Indigenous peoples, and they're calling on the federal government to require an impact assessment for the 413 project under the Impact Assessment Act. Thank you, Madam Speaker.
Presenting petitions. Questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, Madam Speaker, I would ask that all questions be allowed to stand at this time, please.
Great. So ordered. Ordre du jour.
Orders of the day.
Orders of the day, ordre du jour, government orders, government bills commons, resuming debate at second reading on Bill C-27, Digital Charter Implementation Act 2022.
Resuming debate, the Honourable Member for Hamilton Centre.
Merci, Madame la Présidente.
Thank you, Madam Speaker. I will be splitting my time with the honourable member, the unbelievable member for Rosemont-La Petite Patrie.
We need to rise today on Bill C-27, which is an act to the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act to make consequential and related amendments, Madam Speaker. And it's the amendments that I am particularly interested in today, as do Democrats. We will be supporting this at second reading. We support the need for modernizing Canada's privacy laws and establishing rules around data governance and empowering the Office of the Privacy Commissioner to bring enforcement actions to protect consumers and citizens. And this bill takes some of those steps. However, there is a need to ensure the reforms are robust and effective and will certainly require a long list of amendments to achieve these goals, in my opinion, here today. I'm going to be referencing two important works that have been presented. One is from the Centre for Digital Rights, entitled Not Fit for Purpose, Canada Deserves Much Better. And if you'll take any note from the title of that, you'll see that there are some concerns, Madam Speaker, to this bill. However, we recognize that amending this privacy legislation is because there are already glaring shortfalls in PIPEDA and its urgent need for updating. Technology continues to evolve, and data-driven business continues to move away from a service-oriented approach to one that relies on monetizing personal information through mass surveillance of individuals and groups. So while these businesses, through mass surveillance, find new ways to expand their surveillance and methods of monetizing our personal information, Canadians' privacy is increasingly put at risk. The GDPR is the bar which is considered the adequate level of protection currently, and one in which, if we were to do a little bit of comparing and contrasting, would see that this bill tends to fall short of what the European Commission has done. So what this means for us is that the ability for personal data to flow to Canada without any further safeguards is at risk, Madam Speaker. There's also been pressure from industry and advocacy groups, the Privacy Commissioners of Canada and abroad, and the privacy and data governance experts. We, in fact, I think in this particular bill, the government side has fallen short in its engagement with people, and I'll get to that in a moment. Because, when we're in these technological environments, it's an ecosystem that goes well beyond our borders. We're talking about what it's like.
Can I ask members that are having conversations to please take them to the lobbies? Thank you. The Honourable Member for Hamilton Centre.
Thank you, Madam Speaker. I'm assured that the honourable members from the other side are about to take some good notes from the recommendations that we put forward and are probably discussing amongst themselves how they can improve upon these serious gaps and perhaps have some public engagement on this, because we are not subject matter expertise in this House when it comes to this type of technology. And it's not clear if there's been any public engagement specific to Bill C-27 as it's proposed. There was a public engagement around the creation of Canada's digital charter, titled the National Digital and Data Consultations. That happened back in 2018. But as I'm to understand, there's only about 30 such discussions that were had, and that fell dearly short. The majority of digital leaders are from the private sector, and there was only a couple of universities that were involved. So it's unclear about who this government is consulting with when they deal with this type of surveillance capitalism and the risks that it provides and presents to consumers. So let's get right to the point, Madam Speaker. What are the gaps that exist in this legislation, and how does Bill C-27 compare to the ideal privacy legislation? Well, there's many gaps that exist. Clearly, it doesn't compare to the GDPR, but it also falls short of privacy legislation that is currently being proposed in La Belle Province of Quebec, New Zealand, California, the state of California. For example, in California, the California Consumer Privacy Act and the California Privacy Rights Act and their Children's Online Privacy Protection Act have all presented more robust solutions to what's before us here today. In addition, there's privacy protections that come into effect under the CCPA that we should be considering, Madam Speaker. We need to ensure that the right to protections that come under effect include the right to know, the right to delete, the right to opt out of sale or sharing, and the right to non-discrimination. Consumers also, under that legislation, have the right to correct inaccurate personal information and the right to limit the use and disclosure of sensitive personal information collected about them. So there's lots that's out there that we should be considering when it comes to amendments. Examples of gaps within this bill, and I'm going to list them to be on the record. It does not promote the development of data stewardship models. It does not require that organizations take into account the potential consequences to individuals and societies through measures such as privacy impact assessments of a breach of security or safeguards. There's no express section in C27 dedicated to cross-border data flows. There's no privacy impact assessment done to address any additional risks, which should be identified, justified, mitigated, and documented in a privacy impact assessment. There's no assessment of the broader level of privacy rights protections in foreign jurisdictions, which is a very important conversation, particularly this week in this House, including how Canadians' privacy rights can be enforced. Now, this Act does not include specific rules that are applicable to data brokers, and this is an important party. These are third parties who are not service providers. There should be a fiduciary duty to individuals should their data processors act as intermediaries between individuals and the data collectors to ensure that such service providers only use personal information entrusted to them for the purpose intended by the individuals. This Act does not provide the right to the disposal with respect to search engines indexing of personal information where it could cause harm to the individual's privacy or reputation. It doesn't include the language that was in PIPEDA regarding individual access, where it's providing an account of third parties to which it has been disclosed personal information about an individual, an organization. Should there be an attempt, there should be an attempt that is specific as possible. This Act does not have the right of individuals to express their point of view to a human intervener or to contest decisions. Where, when you look at AI and when you look at how algorithms are working in society today, they are inherently flawed, Madam Speaker. In fact, there's another study that I would reference, which is the AI Oversight and Accountability in Protecting Human Rights, which has commented on this. And this was authored by a series of subject matter experts who listed a long list of needs for adequate public consultation, the need for proper oversight of AI-DI to effectively regulate the AI market in Canada. The Commissioner needs to be able to be an independent agent of Parliament, and we need to empower an independent tribunal to administer penalties in the event of a contravention and outline the best practices for auditing and enforcing the law. Madam Speaker, there are dozens of recommendations contained within both reports that as New Democrats, we will be presenting to this government at the appropriate time at committee. It is clear, though, from the body of the preliminary work that's been done, this bill is inadequate as it stands. It is too big to cover adequately AI and consumer protections. It is my belief that those should be split up. That has always been our belief, so that we can adequately have an investigation to ensure that consumer protections are met, that surveillance capital doesn't continue to profit off of our most personal information and data, and that ultimately we have safeguards with robust and very firm platform for which these organizations and businesses and companies and in some instances foreign countries, Madam Speaker, are held to account when they violate our rules. Thank you very much, Madam Speaker.
Questions and comments. The Honourable Member for Hamilton Mountain.
Thank Thank you, Madam Speaker, and I'd like to thank my friend from Hamilton Centre. I see him all the time in our hometown, and we serve together on the Committee for Access to Information, Privacy and Ethics. And I would like to ask whether he thinks there's urgency to this legislation, given the fast pace that this technology develops and that companies are using to develop, that can sometimes be invasive and can violate Canadians' privacy.
For Hamilton Centre.
It's clear that Moore's Law has extrapolated over the inaction of the Liberal side government for the last 8 years. We absolutely should have moved on this. However, we need to do it right, Madam Speaker. It is important that we don't put a piecemeal effort forward to try to keep up with technology that has surpassed our grasps. There are subject matter experts who know this material better than we do. We need to have an engagement with them at committee, and we need to be able to provide independent safeguards so that when violations happen, the legislation actually has its teeth to address it.
Honourable Member for South Shore St. Margaret's.
Thank you, Madam Speaker. Thank you to the member for Hamilton Centre for his excellent speech. I'm curious if he would expand a little more on the artificial intelligence section of this bill. Our reading of that bill says basically we've got this vague definition of what artificial intelligence is. We don't really know, so trust us. The minister will define it all in regulation. Then the minister will enforce the regulation. Then the minister will investigate if you've broken that regulation, and the minister will impose fines on that regulation without ever having to go to Parliament or decide anything. So he's going to be judge, jury, and executioner on artificial intelligence on something they haven't defined. I wonder if you would comment on that.
Member for Hamilton Centre.
Thank you, Madam Speaker. And that is an important question. Bill C-27 needs consistent, technologically neutral, and future-proof definitions, both to the Consumer Privacy Protection Act and the AIDI within Bill C-27. It should provide for a definition of AI or algorithmic systems that are cohesive across both laws, and the definition for AI ought to be technologically neutral and future-proof. That's the question that I just answered to the previous speaker, Madam Speaker. And a potential pathway for regulation is to define algorithmic systems based on their applications instead of focusing on the various techniques associated with machine learning and AI.
Questions et commentaires. Questions and comments. The Honourable Member for Kitchener Centre.
Thank you, Madam Speaker. I appreciate hearing the member for Hamilton Centre's speech on Bill C-27. I'd like to hear more from him, in particular, Section 18.3, this section that talks about a legitimate interest for an organization to collect a person's private information without consent. There's been concern shared here with respect to how open-ended this legitimate interest could be, and I wonder if the member would reflect and share more about his concerns, if any, with the way that the bill is currently written. Thank you.
The Honourable Member for Hamilton Centre.
Thank you very much, and that is also an important question, because I think what the member didn't reference, which I'll reference specifically, is the instances where governments use this information. And I think that informed consent is an inherent right to privacy and protection. There needs to be the AIDI must apply to government institutions, given that the AIDI only currently applies to the federal private sector, as government institutions are explicitly exempt from this, Madam Speaker. It is imperative that AIDI's framework be brought in to include government institutions, and let's be very clear. Individuals ought to always have informed consent about where their information and data goes. There ought not be situations outside of warrants expressed through our legal system that allows for the collection, maintenance, and distribution of personal information online.
The Honourable Member for Beauport-Limoilou. Thank you, Madam Speaker. At the beginning of his speech, my colleague talked about breakthroughs in Quebec with Bill 25. Bill C-27 appears to attempt not to run afoul of Bill 25. In my colleague's view, is that one of the changes that should be made to guarantee that Quebec's Bill 25 will not be violated by this bill?
In 15 seconds.
Well, I have a growing appreciation for the Bloc's propensity to be here as representatives of the Quebec legislature. I'm not here in that capacity, but I will say that any legislation we put forward does have international ramifications. that must be met in terms of the international standards related to the protection and collection of data. Thank you.
Reprise du débat, l'honorable.
Resuming debate. The honourable member for Rosemont-la-Petite-Patrie. Thank you very much, Madam Speaker. I'd just like to take this opportunity while I'm on my feet to mention that today is the 85th day of the blockade in Armenia that is preventing Armenians from getting access to care and food. The situation has been condemned by Amnesty International and the European Parliament, and the case is before the European Court of Justice, and I would encourage this Parliament to put more pressure on the situation so that Armenians can have better access to food and health care. I rise today to speak to Bill C-27, an act to enact the Consumer Privacy Protection Act, the Personal Information Act, and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act. So it's a lot of ground to cover. I'd like to begin with the bit on AI. We in the NDP were a bit concerned that after C-11, C-27 would include this whole new part on the AI Act, which in our view is a separate topic that should be dealt with separately. It's a huge area in and of itself, so it was a good idea to split the bill so that it can be studied separately. In my riding, there's a whole AI hub developing, and there are hundreds, if not thousands, of professionals working in that area, and people are a bit concerned that the federal government seems to be acting hastily here with such a complex subject as AI. And there is already legislation in the U.S. and in Europe, and we really need to take the time to make sure our laws and regulations here in Canada are consistent with what's going on with our competitors or our trade partners, just so that it's easier afterwards to attract talent here to Montreal, Toronto, Vancouver, all over Quebec and Canada, so that there's no incompatibilities, so that this doesn't become needlessly a hindrance. When it comes to protecting personal information, people are unfortunately aware of the fact that we need to modernize and adapt our laws and regulations because it's one scandal after another, Madam Speaker. Data leaks, personal information leaks, and so on, and everybody's been affected in one way or another. Just some quick examples. There were problems with Yannou Marriott, Desjardins, Facebook. They've all revealed the importance of steps to protect the victims of personal data theft in various countries. And for example, there were regulations in the U.S. in 2019 around the breaches from Equifax. Equifax is one of those big companies that people need to use for their credit rating when they want to take out a loan. So it's a pretty big deal. And we here in 2019, the Privacy Commissioner found that Equifax had not met its obligations toward Canadians and Quebecers. And so there was a voluntary compliance agreement entered into, but there were no penalties and no compensation for victims here in Canada and Quebec. So those are just a few examples in recent years that show how out of date our legislation is. So that's why we'll be supporting this bill, we in the NDP. We want it to go to committee because we see that there are all kinds of gaps and shortcomings. So we want to strengthen the Privacy Commissioner's role so that there's better enforcement to protect consumers and Canadians and the members of the public. There are currently shortcomings in this bill, and in fact, it's a bit of a backward step from C-12, which was the legislation in the previous Parliament before the election. So protecting privacy involves everyone. In a digital world where social media and giant webs are, the web giants are taking up more and more space, they're more and more powerful. We use those services, we enjoy them, but we in a way have become the product Our personal information is the source of significant profit for those web giants. And our information is used to target advertising to us. So we're targeted in terms of our personal choices, our preferences, and our searches. Those companies are able to make profiles of us, and then ads are targeted towards us. So we become the target. We provide this information freely and voluntarily, and then that information is used to target us. We should be paid, some people say, for that information that we provide free of charge. And that information enables companies to make bigger profits off us. So the legislation to protect personal information has to be bolstered, and people need to be more aware of what it means when they provide all this information about our purchasing habits, our traveling, our searches, and so on. This is something that we need to delve into further. The bill is promising in one sense because it creates a whole bunch of new regulations and a new tribunal. We see that in a positive light, but it doesn't go far enough. For example, there's a right to take an action to sue privately, but it doesn't provide for any compensation for victims of privacy breaches, unlike in the U.S. So there are a number of things that are ineffective. There are very few remedies set out in the bill, even though there are some new provisions around the new tribunal and so on, but there's very little in the way of recourse or remedy. So in the NDP, we had done some work. We proposed a digital Charter of Rights for the public, and that right would provide new requirements in terms of consent and how long data could be kept, new powers for the privacy commissioner, higher, stiffer penalties, more consequences, transparency around the algorithms that these companies use, and around the cases of abuse. So I think we could go further with this NDP's idea of digital Charter of Rights so that we could strengthen this bill and improve it with that kind of thing. And once again, Madam Speaker, I'd like to say that this bill is a lot of half measures, a lot of half steps, kind of in the right direction, but it just doesn't go far enough. There's still a significant imbalance between the individual rights and the corporate rights on one hand and on the other. And once again, we see all too often with the Liberals that the corporate interests tend to take precedence over the public interest. For example, in the preamble to Bill C-27, there's an attempt to present privacy as a fundamental individual right, but it doesn't say that privacy is a right in and of itself, not just an essential part of an individual right. So it should really, that's something we could change. The right to privacy should be presented as an individual right or freedom. There are also shortcomings in C-27. An individual under this bill would have less control over the collection and use and communication of their personal information, even less than what was provided for in C-11 under the previous Parliament. So this is crucial. If you don't have control over your personal information and how it's used, well, then it's the Wild West. It's a free-for-all, and that's the status quo, really. So this is a backward step in our view, and we in the NDP would like to amend the bill to restore that balance of power. The bill also would depersonalize data, but it remains personal information unless there are exceptions. And then there are some exceptions set out, exceptions in Section 20, 21, Paragraph 29, there's all kinds of exceptions in this bill. There are about a dozen clauses in the bill that create carve-outs or exceptions, and that's extremely dangerous. And it seems to me that that will give the web giants a whole bunch of outs, a whole bunch of loopholes that they can use. They can use those exceptions to get around the protections that were intended here. So we're going to support this bill at this stage, but we think there's a lot of work to do to improve it. Questions and comments?
Quinty.
Thank you, Madam Speaker, and thank you to our honourable colleague for a great speech. Certainly, I think from the Conservative side and from the NDP, it seems like we're on the same page when it comes to looking at privacy, protecting privacy, and making the statement that privacy should be a fundamental right, not only in the preamble, but also in the clause statement. And the purpose clause statement is very important because from that is what the bill is derived from. The definition of privacy, the fundamental right, then goes throughout the rest of the bill. One example this week that came out was our children use a game called Fortnite. A lot of other games my children spend a lot of time on sometimes, but Fortnite was found to be a breach of error in the U.S. for exploiting our children, taking their data and selling that. Can the member please answer for me, how important is it not only protecting our adult fundamental right to freedom, but also our children's fundamental right to freedom? Thank you, Madam Speaker.
The honourable member for Rosemont-la-Petite-Patrie. I'd like to thank my colleague for his question. That is a question that we have to address. And as the father of teenagers, I understand how important the issue of social media is and privacy and how their data may be used. So once again, this bill doesn't go far enough in that respect. The bill has an interpretation clause concerning minors and sensitive data, but there's no definition of explicit orders about what sensitive data means. So again, it just goes halfway. It doesn't go far enough in explaining what sensitive data means for someone who's not 18 yet. So it should be a lot clearer. We need to amend this to make it a lot clearer. The honourable member for Repentigny. Thank you, Madam Speaker. I'd like to thank my colleague from Rosemont-la-Petite-Patrie for his speech. I don't know this area really well, but I'll take a stab at it. So I just have a question about the fact that Canada is still the Wild West, digitally speaking. We fall short in a lot of areas. So this Bill C-27 is a bit of an answer to the European legislation because Canada's rules weren't really meeting the expectations of the European Union. So my question is much broader. What does my colleague think about how slack Canadian governments have been, one after the other? They've been soft in all kinds of areas: transportation security, cybersecurity, and the environment, of course. Our federal governments have been very slack in these areas. So what does my colleague think, and what are the repercussions for financial circles and so on? The honourable member for Rosemont-la-Petite-Patrie. I'd like to thank the member for Repentigny for her question, Madam Speaker. And it gives me the opportunity to raise the fact that it's really laissez-faire with this neoliberalism. Corporations have been able to do whatever they pleased, and progressive forces have always been there to push back, to push our governments to do more, to protect people through regulations and so on. In terms of personal security, we're talking about data security here, but it could be personal security, could be railway security. Look at Lac Mégantic, the disaster there, the lack of inspections and ensuring that transportation meets all the standards. I think a responsible government would not allow those big companies to inspect themselves and to regulate themselves. So I think and in order to just rack up bigger and bigger profits.
Thank you, Madam Speaker. I'm wondering if the member could provide his thoughts in regards to when he's critical of the legislation, saying that there's many things in which it's missing. A number of the references that he refers to could easily be done through regulation. And the legislation sets in place a very substantial framework that is there to protect the privacy of Canadians. And a number of things that have been raised already this morning could in fact be done through regulation. And in fact, many would argue might be best done in regulation.
The Honourable Member for Rosemont-la-Petite-Patrie. Thank you, Madam Speaker, and I'd like to thank my colleague for his question. But it's a bit of a leap of faith to say that regulations will be our savior. The bill itself has to be clear. The bill itself has to give some clear indications about what the regulations should contain. We can't just cross our fingers and hope the regulations will save the day. But Bill C-27 provides no guarantee that a person requesting that their data be destroyed will actually get what they want. So that's something we need to work on to make sure that the regulations eventually can truly do the job.
Parliamentary Secretary to the Government House Leader.
Yes, thank you, Madam Speaker, and it's a pleasure to be able to rise and speak to Bill C-27 today. And as I put forward to my friend in the form of a question, when we think of C-27, I like to think that the government is on the right track in ensuring and continuing to protect the privacy of Canadians in many different ways. You know, yesterday we had a debate on C-26, and C-26 was on cybersecurity, Madam Speaker. So I think that if you take a look from a holistic approach in regards to what it is the government has been able to accomplish through legislation, and ultimately in certain areas in terms of developing the industry through budgetary measures, that Canada is indeed in a very good position in comparison to our peer countries around the world, Madam Speaker. And I don't say that lightly because I do believe, as I know all members are very much concerned about the issue of privacy. And that is in good part why we have the legislation today, Madam Speaker. You know, if you take a look at the last time in which we have seen the type of changes that we are proposing, you'd have to go back 2 decades ago, 20 years ago. Reflect on the time 20 years ago. We didn't have iPhones. Facebook didn't exist, Madam Speaker. In fact, if we go a little further back than that, you know, when I was first elected, and I've made reference to this in the past, when you clicked into the internet, the first thing you heard was the dial tone. The buzz, then the dial tone, and then the click, 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 and then you're magically connected to the world. How far we have advanced in a relatively short period of time, Madam Speaker. You know, just the other day, I'm on the internet and I'm making a purchase that is going to be delivered. Never had to go into the store. In fact, it involved me doing a little bit of design work on the computer. Then I make a purchase, and now I am told yesterday it was actually delivered at my home, and that was just last week. The amount of information that is out there is absolutely incredible and very hard to imagine the type of data and the risk factor that is out there. And that is why it's so important that as a government, we bring forward substantive legislation that's going to be there to protect the privacy of Canadians, to ensure companies are held accountable, and in yesterday's situation, Madam Speaker, to protect from security threats that are very strong and very viable. You know, it's interesting, yesterday in listening to the debate for a number of hours, and I get the sense that that's what's shaping up already today, is that there's a wide spectrum of support. The NDP are supporting the legislation. My understanding is that the Conservatives are supporting the legislation. The Bloc, in principle, supporting the legislation. The province of Quebec has actually made some significant gains on this whole front. So I'm not surprised that members of the Bloc were the members of the Quebec caucus within the Liberal caucus, very strong on the issue, whether it's the cybersecurity or the privacy issues of C-27, what it is that we're debating today. I raise it because I do believe that it doesn't matter what side of the House that one happens to sit on, that it is legislation that is worth supporting. As I indicated, it's been 20 years since we've seen those, since we've seen substantial changes to the legislation. And the expectation is very high that, in fact, we will not only be introducing the legislation, that with the cooperation of members opposite, that we're going to see this legislation pass through, Madam Speaker, in a timely fashion. You know, being an optimist, I'd like to be able to see it pass before summer, and it is possible. I realize that it would require a great deal of cooperation from opposition parties, but I do believe that it is doable, especially when I hear the types of comments that I've already heard this morning. The legislation is not meant to address every matter that Canadians are having to face in regards to the digital world. That's not what it is designed for, Madam Speaker. As I indicated, the legislation, whether it's this one or C-26, goes a long way in establishing a solid base for a framework that will enable the government of the day, which is held accountable through opposition, the opportunity to do a lot of work on an area or in an area that we need to see a higher sense of security and protection. The one member across the way asked the issue of engagement, and there has been a great deal of engagement. I can assure the member, whether it's from a constituency perspective or it's from a ministerial perspective, and I would even suggest the member would have to take some credit in terms of from an opposition perspective, that there has been a great deal of dialogue. This is not a new issue. This is an issue that's been in the making for years now, Madam Speaker. You know, there have been some factors that are beyond government's control in terms of the manner in which it can bring forward legislation. For example, the worldwide pandemic and the requirement for substantial legislation in order to support Canadians and have the back of Canadians. So that was issues of that nature, along with numerous other pieces of legislation. I wouldn't want to give a false impression that this is not an important issue for the Government of Canada. I believe, at the end of the day, Madam Speaker, that based on comments that I've heard both on C-26 and C-27, that the legislation does establish a solid footing or framework, whatever you want to use, what kind of terminology you might want to use, to see it at the very least go to committee. The principles of the legislation are in fact endorsed and supported, from what I can tell, and please correct me if I'm wrong, by all sides of the House. We will have no doubt other legislation that might be somewhat more controversial, where you have opposition in real opposition to legislation, and that would enable more time for debate on that type of legislation, Madam Speaker, if we could somehow recognize the value of this and saying, yes, given that there's so much support for the principles of the legislation, that we allow it to go to committee where members of Parliament are afforded the opportunity to go into the nuts and the bolts, the details, where we have representations from different stakeholders coming to the committee to express their thoughts and their opinion on the legislation, where members can directly find out from the minister what kind of consultation has taken place. Doesn't have to accept my word for it, but I can assure the member that there has been a great deal of consultation. But he'll be able to hear that firsthand from departmental officials and the minister and so forth. I believe that the government has done that it has done its work in bringing it to the point where it is today, Madam Speaker. I believe we have seen ministers in their opening remarks and in their response and the cooperation with opposition members that if there are ways in which we can improve the legislation, what this government has demonstrated very clearly in the past is that we are open to where amendments can improve upon legislation to the benefit of Canadians, that we will accept those type of amendments, Madam Speaker. We will support those type of amendments. You know, that's one of the things in which the current Prime Minister, I believe, has been very good in terms of sending that message. Now, it could be because of years in opposition, when opposition never had amendments being accepted by the former Prime Minister, Stephen Harper. But at the end of the day, if there's ways in which we can improve upon this, and I hear, again, yesterday on C-26, and already today on C-27, members have genuine concerns, and I don't question those concerns. But I do believe that it is helpful if they can look at those concerns, and if they already have ideas that they believe will improve the legislation. Nothing prevents members of the opposition or government members to be able to provide those amendments or thoughts in advance to the ministry, so it would even potentially allow for a deeper look into it and see if in fact something is doable. So when the NDP talk, for example, about digital rights for Canadians, you know, there's a great deal of concern that, yes, we need to ensure and recognize whether it's consumer rights, privacy rights. These things are something in which we all hold very close to our heart, Madam Speaker. We all want to make sure that the interests of Canadians are being served. When I take a look at the specifics of the legislation, I highlighted 3 parts that I wanted to make reference to, Madam Speaker. CPPA will strengthen privacy enforcement and oversight in a manner that is similar to certain provinces and some of Canada's foreign trading partners. It is important, Madam Speaker, that we not just look internally, that there are jurisdictions, whether it's nations or provincial entities, that have already done some fine work in this area. We don't have to reinvent the wheel. And working with and looking at other forms of legislation that's there, I think is a very positive thing. It does so by granting, in particular, Madam Speaker, it does so by granting the Privacy Commissioner of Canada order-making powers, which can compel organizations to stop certain improper activities or uses of personal information, and order organizations to preserve information relevant to an OPC investigation. Madam Speaker, this is significant. You know, we need to think in terms of that technology that I make reference to. I can remember a number of years back where a pizza store was actually becoming computerized. And what they were doing is that as someone called in and made an order, they record the telephone number. Obviously, they get the name and they get the address. Personal information such as that, Madam Speaker. And I remember talking to the franchise owner, who I happen to know quite well, Madam Speaker, explaining in terms of how the collection of data, if used appropriately, can not only complement the business, but it can also complement the consumer, Madam Speaker. And this is something that's, you know, maybe 20 years ago. Contrast that to, you know, go to your iPhone. Look up some of those applications that you'll see. And the one that comes to mind is a true Canadian application and a true Canadian franchise, Tim Hortons. You know, my wife never ever followed hockey, but nowadays she does because of Tim Hortons. You know, you can win free cups of coffee by picking who's going to score goals or gets assists. I'm not exactly sure how it works, Madam Speaker. But Tim Hortons comes up with a program that is actually collecting data from people. It is a program that allows them to send out all forms of notifications. It could be sales of product. It could be something like NHL standings. It really engages the consumer. It's an incredible amount of data that is actually being collected. And Tim Hortons is not alone. You can go to all the virtual major franchises and you will find the same thing, Madam Speaker. And it's just not the private sector. Yesterday, when we were talking about cybersecurity, one can easily understand and appreciate the sensitivity of collecting information, even if you're a Tim Hortons or a Home Depot, but also many of those government agencies. The amount of personal information, for example, that Manitoba Health has that's all computerized, and the type of personal information that you will find there. Doctors' offices. The digital world, in a very real and tangible way, has changed to the degree in which many would argue, including myself, things like internet access is an absolute essential services nowadays. It's something in which we all require, Madam Speaker. But with that incredible growth of data banks, both private and government, and I would throw in nonprofit and the many other groups that collect data, Madam Speaker, in the last 15, 20 years, it has been substantive. And that is the reason why today that we have the type of legislation that we have before us. Whether it's C-27, which ensures that we have something that's in place that actually gives and provides a consequence. To give you a sense of that consequence, Madam Speaker, the new law will enable administrative monetary penalties for serious contraventions of the law, subject to a maximum penalty of 3% or 10 million of a global revenues, whichever is greater, and fines of up to 5% of revenues or 25 million, whichever is greater for the most serious offenses, Madam Speaker. I wanted to highlight, I said three things, so I'll get on to the second point. The Personal Information and Data Tribunal Act will establish a new tribunal which will be responsible for determining whether to assign administrative monetary penalties that are recommended by the Privacy Commissioner following their investigations, determining the amount of penalties, and hearing appeals of the Privacy Commissioner orders and decisions. The tribunal will provide for access to justice and contribute to further development of privacy expertise by providing expeditious reviews of the Privacy Commissioner's orders. The third point, Madam Speaker, I see 2 minutes left. AIDA or AIDA will impose a duty to act responsibility by requiring organizations designing, developing, deploying, or operating high-impact artificial intelligence technologies to put in place measures to proactively mitigate risks of harm and bias in the development of these technologies. Already, Madam Speaker, with less than a minute to be able to talk, and I haven't even touched on the AI file. AI is something, and I made reference at the very beginning in terms of just the financial investments of this government in encouraging the growth of that industry in the different regions of our country. And that's why I say, not only is the Government of Canada bringing in the type of securities that are absolutely important for Canadians from a privacy perspective, to encourage continual growth in the area and have these protections in place, but also through budgetary measures to ensure that we continue to enhance the opportunities of Canadians, Madam Speaker. We take a look at that digital world today and where it's going to be tomorrow, and it's very hard to imagine, at least for myself, Madam Speaker, witnessing the growth of the digital world over the last 20, 30 years and how far we have gone. This legislation is a modernization. It is legislation that we all can get behind and support. I would encourage members, no matter what party they are, to support it, and let's see it go to committee where the committee can do its fine work and see if we can even...
Questions and comments. The Honourable Member for Saskatoon West.
Thank you, Madam Speaker, and thank the member for his speech. And certainly this is important legislation, and it is something that's actually quite needed in our country to get a handle on the protection of people's privacy, and as he was just speaking about artificial intelligence. One question I have for the member relates to the area of regulations. There is so much in this legislation that's dependent upon future regulations that will be written. So just wondering why those regulations weren't presented with this legislation, and failing that, when can we expect to see the regulations? Because so much of what's being talked about here really depends on how it's implemented through the regulations.
The Honourable Parliamentary Secretary.
Yes, Madam Speaker, and that is one of the reasons why I think it's important, once it gets to committee, that you will have the opportunity to get a better sense of the types of regulations that will be put into place to support the legislation. There's a different way, there's another way of looking at it. When you have a legislation such as this that's being presented and then going into committee, Madam Speaker, opposition members and government members on all sides of the House have the opportunity to be able to express their thoughts and ideas and concerns with respect to the legislation even before the regulations have been drafted. I wouldn't want to give the impression to the member opposite that we have a pile of regulations, and the moment that the legislation passes, these regulations are going to be put into place. I suspect that there's a lot of fine-tuning going on.
Questions et commentaires, l'honorable député de Repentigny.
Questions and comments. The Honourable Member for Repentigny. Thank you, Madam Speaker. I thank my colleague for his speech. He seems to be very knowledgeable about almost all files. In Canada, privacy protection is a shared jurisdiction, so C-27 thus should not apply to provinces which have equally demanding requirements as C-27. In February 2022, Quebec's National Assembly adopted a law, a strong one, so can the member guarantee us that Quebec businesses will be excluded from the federal law?
Yes, thank you, Madam Speaker, and I appreciate the question. The bill is aligned closely with and approaches in other jurisdictions, both in Canada and internationally. The CPPA does not apply in jurisdictions where the provincial law is deemed substantially similar, which is likely to include provinces like the province of Quebec. I think that it's important to recognize that the national government does have, and this legislation clearly shows that, a responsibility, and we're living up to that responsibility, and that's one of the reasons why maybe we need to look at the regulations that I made reference to in the previous question, but I don't believe that there is going to be the overlap that is going to cause issues in the province of Quebec or BC or any other jurisdiction.
Questions and comments, the Honourable Member for Hamilton Centre.
Thank you very much, Madam Speaker. And the Honourable Member spoke at length about administrative tribunals being a way in which people can access justice as it relates to their appeals processes and so on. But yet, this is in direct contradiction to what the Office of the Privacy Commissioner, who is clearly opposed to the creation of a new personal information and data protection tribunal, citing it would be unnecessary to achieve greater accountability and fairness and counterproductive in achieving quick and effective remedies. In fact, the OPCC states that adding a new level of appeals delays resolutions of cases, especially when the power to impose monetary penalties is limited to the tribunal. So I wonder if the Honourable Member could comment how the OPCC argues that the system proposed under Bill C-11 encourages organizations to use the appeal process rather than seek common ground with the OPC when it's about to render an unfavorable decision.
The Honourable Parliamentary Secretary.
Well, Madam Speaker, I guess sometimes one needs to agree to disagree. I look at the tribunal as something that is to the benefit of Canadians. It's an opportunity to ultimately seek fair justice. And at the end of the day, I suspect, I hope, that it will ultimately prevail. If there's ways in which the member can enhance or put in something that might deal with his concerns, if not directly, indirectly, but I think it's important that we keep the tribunal.
Honourable Member for Nepean.
Thank you, Madam Speaker. Madam Speaker, this is long overdue. The current privacy laws were drafted 20 years back when iPhone or Facebook were not in existence. And this advanced technologies like artificial intelligence is ever evolving. They're almost getting changed on everyday basis. Does the member agree that defining, say, things like artificial intelligence in a legislation and casting it in a legislation so that it becomes inflexible, instead of that, will it be better for that we have regulations which will be more flexible, that will allow the ministers and the government of the day to take changes, to make changes as may be required as and when the technologies advance?
Parliamentary Secretary.
Yes, thank you, Madam Speaker, and I appreciate the question from the member, and I think that his overall assessment of the situation when it comes to AI is accurate. And that's one of the reasons why, whether it was in the question that I had put forward a little bit earlier this morning or in my statement, you know, the digital world and the rapid change that we're seeing, I think is going to continue to even get greatly enhanced through AI, Madam Speaker. And I think that by having what we've proposed within the legislation and then allowing for regulation is by far the best way to go. You know, I don't live in fear of AI. I think AI is something that's going to improve the quality of life for Canadians, in fact, for people around the world. Thank you, Madam Speaker.
The Honourable Member for South Shore St. Margaret's.
Thank you, Madam Speaker. I believe I heard the member from Winnipeg North say in his presentation that the Conservatives were supporting the bill. That's incorrect. We're opposing the bill. Not that we oppose the modernization. It's needed, but this bill is inadequate. And the primary reason, there are many reasons, but the primary reason is that it doesn't put personal privacy interest above those business interest. In the purpose section of the bill, section 5, it says that basically they're of equal weight. And then further on in section 18.3, the bill says that a legitimate interest of a business determined by a business is reason that a business can use your data without your permission in a way that they did not get permission for. So those are one of the fundamental flaws in the bill in terms of the idea that personal information of mine or yours or anyone that's listening is mine and should be paramount and superior to that of the business. The business is there just to serve my interest, not of equal value. So I'd like the Honourable Member to comment on that.
Good question. The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. And that's why I was reflecting on Bill C-26. And if you look at the debate that took place yesterday, and that was on cybersecurity, dealing with the digital world, at the end of the day, the Conservative member after member was standing up saying, yes, we're going to support the bill, but we have a lot of problems with the legislation. But the principle of C-26 is something in which they support. So I kind of made a leap, and apparently the wrong leap, by seeing the Conservatives in principle support the privacy of Canadians and legislation that will give and enhance privacy of legislation. And I guess I shouldn't have made that particular leap. Inconsistency is something that's fairly well known from the Conservative caucus, and I'll try my best not to make that sort of a mistake going forward.
L'honorable député.
The Honourable Member for Beauport-Limoilou. Thank you, Madam Speaker. My colleague has shown openness to amendments, and amending a bill is not something that is done lightly, and because the matter needs to be studied in depth by calling on experts, because parliamentarians are not experts on some of these matters, especially artificial intelligence. So we also need to draw comparisons with international standards so we can agree on best practices. So does the government intend to allow parliamentarians to study this bill in depth, or does it intend to impose time allocation to shut debate down? Thank you.
The Honourable Parliamentary Secretary.
Well, thank you, Madam Speaker. And I said at the very beginning of my comments how wonderful it would be if somehow we could pass this bill before before summer comes. I suspect that that was maybe a little optimistic. Hopefully, we can do it before the end of the year. The government needs to get a sense of cooperation from at least one opposition party, and we're hopeful that there will hopefully be more. It would be nice to have that unanimous type of consent moving forward. I would have thought that the principles of the legislation should at least allow us to get it to the committee stage, where the member herself makes reference to how there are some possible changes, and it's important that the government be open to ideas, and that's why I say if there are specific ideas.
And we have to resume debate. The Honourable Member for Saskatoon West.
Well, thank you, Madam Speaker, and of course it's a privilege to rise in this House, and another day and another debate about an NDP Liberal piece of legislation about internet freedom in Canada. The good folks on the west side of Saskatoon have heard me speak in this place about Bill C-11 and C-18, which are two bills aimed at controlling what you see and post on the internet. Today we're dealing with Bill C-27, which is aimed at protecting the online data of Canadians. This legislation is meant to put safeguards around the use of artificial intelligence and establish rules around internet privacy. Sounds good, sounds noble, and sounds like something that we should support. And to a certain degree, I do support these initiatives. But I have deep reservations with this legislation as it exempts the Government of Canada from these very safeguards. Do we as Canadians need the protections in this bill from companies? Absolutely. But we also need protection from government, especially this NDP Liberal coalition government that wants to take away some of our liberties and freedoms. Madam Speaker, some on the other side may accuse me of fear-mongering about the NDP Liberal suppression of civil liberties and freedoms on the internet. I am not. Let me lay out the facts, and the people in Saskatoon West can decide for themselves. Bill C-11 is the first piece of legislation meant to strip us of our rights to free speech on the internet. Conservatives such as myself and free speech advocates have been warning that the provisions put in place by the NDP Liberals to have government-appointed gatekeepers decide what is acceptable speech or not in Canada will lead to disaster. We've already seen that a prominent University of Toronto professor has been threatened with revocation of his license and livelihood for tweeting out against this legislation and the current Prime Minister. Imagine what will happen when this Prime Minister has the full weight of the law to simply muzzle this type of speech. Anyone who disagrees with him will be silenced and will be fined, lose their livelihood, and what's next? Go to a re-education camp? We all know that the Prime Minister's fondness for the basic dictatorship of the People's Republic of China, heck, he doesn't even mind if the People's Republic of China funnels money to his family foundation and tilts elections towards the Liberal Party in this country. Now, how about the second piece of legislation meant to limit our internet freedoms, Bill C-18? That legislation allows government-appointed gatekeepers to decide what is or isn't news in Canada and forces private companies to block content they don't like from their feeds and search engines. So if there is a story critical of the NDP Liberal coalition and their Prime Minister, they call it fake news and they ban it. If there's another fawning story by Andrew Coyne in the Globe and Mail about the Trudeau Foundation and the Communist Party of China, it is forced to the top of everyone's newsfeed and search engine, like it or not. When I spoke about C-18 in December, I warned of the consequences that this legislation will have. Specifically, I mentioned conversations I had with Google and Amazon Web Services and the impact on how they deliver services to Canadians. Google flat out told me that they would simply get out of the business of delivering any and all news to Canadians, as they didn't want to become an instrument of the Canadian government to spread partisan messaging for the party in power. And just last month, they began beta testing how they could shut down their news service for Canadians. We need a 21st century solution to this problem, not one based on ideas from 40 years ago. This bill, C-27, is supposed to protect people's data from corporations. Do we need that? Yes, we do. But what we need as well is protection from this NDP Liberal government when it comes to privacy. Bill C-27 completely fails us in that area. The government has dragged their heels on internet privacy for years, and unfortunately it has been a pattern of theirs to consistently breach our digital privacy rights, We saw it when they waited till just last year to ban Chinese telecom giant Huawei from operating in Canada, while other countries did the right thing years before us. We saw it with the $54 million Arrive scam app, tracking Canadians' border travel up until September 30th. And the public bank account freezing for people who donated to the truckers last year. The list goes on and on. So in the words of Alanis Morissette, isn't it ironic when we hear this government start to talk about online privacy rights? I just hope they learn to start respecting the privacy of Canadians. So let's take a look and see if this legislation actually protects the online privacy of the people in Saskatoon West. After all, they are rightfully distrustful of government and corporations when it comes to assessing their data. Here are some examples showing why they're distrustful. Tim Hortons tracking the movement of users after they've ordered something on their app. The RCMP using Clearview AI to access a data bank of more than 3 billion photos pulled from websites without user consent. And we cannot forget TELUS giving the federal government access to the movements of over 33 million devices over the course of the pandemic. When governments abuse their power, it destroys the level of faith that Canadians have in their institutions. In fact, if we look at polling data, we see that the number of Canadians that have faith in their government is at an all-time low. With scandals like these, it's no wonder why. If we want to improve the level of trust held between individuals and institutions, we must look at protecting Canadians' private data. If we dive into this legislation, it seems the intent is to create a level playing field between citizens and companies when it comes to how their data is used. However, if we look into it further, the balance between businesses using business data and the protection of our privacy is off. The bill, as it is currently written, skews towards the interest of corporations rather than the fundamental rights of individuals. There are too many exceptions granted to businesses in this legislation. Some are so broad, it's like the legislation never existed at all. For example, business activities are exempt if a reasonable person would expect a business to use their data, without including the definition of what a reasonable person is. The concept of a legitimate business interest has been added as an exemption to consent. How does one determine if a business interest outweighs the privacy rights of an individual? Finally, this bill does not recognize privacy as a fundamental right. This absence tips the scales away from Canadians and could affect how their privacy interests are weighed against commercial interests in the future. Madam Speaker, artificial intelligence compromises a major component of this legislation. AI is becoming a key tool in today's world, much like engineering was in the last century. In the past, an engineer would sit down and design a bridge, for example. And obviously, the failure of a bridge would be a huge event, with the potential for major disruptions, significant costs, and potential injuries, and even death. Therefore, we have professional standards for engineers who build bridges. But what about artificial intelligence? In today's modern world, AI is used more and more to perform ever more complex tasks. In its early stages, AI was used as a shortcut for repetitive tasks. As the technology advances, it is now being used for much more. In the future, it is not unreasonable to expect AI to play a significant role in designing a bridge, for example. Artificial intelligence also needs to have standards. That's why our universities teaching AI put a big emphasis on ethics, as there are huge implications. I know firsthand of the dangers of unregulated AI systems interfering in our day-to-day lives. On the Immigration Committee, we've studied this issue and looked at how Canada's Immigration Department is using Chinook, a so-called e-tool, to help IRCC bureaucrats assess applications in bulk form. This AI program was introduced in-house by these bureaucrats. That means the software's algorithms are beholden to the beliefs of its creators. The concerning part of all of this is that there is a known culture of racism within the department. And you don't have to take my word for it. The NDP Liberal Minister of Immigration said this of his own department at committee, and I quote, "IRCC has zero tolerance for racism, discrimination, or harassment. However, we know that these problems exist throughout the public service and in our department. We must first acknowledge this reality," end quote. There were no outside consultations done on the use or creation of this artificial intelligence application, and rejection rates have climbed since its introduction. So although I'm pleased that the government is finally looking to add a framework to address concerns surrounding AI, they need to get their own house in order first. I'm going to wrap up with these final thoughts. If we're going to address concerns surrounding our digital privacy, we must listen to Canadians. And many Canadians are worried that this legislation does not protect them. I've met with Brian Short from Open Media, and he said this: Bill C-27 only plays brief lip service to privacy being a fundamental right in its preamble. Bill C-27 fails to do the more important task of inscribing the privacy rights of people as being more important than the business interests of companies, end quote. This bill is supposed to be about protecting Canadians' privacy, yet completely avoids inscribing privacy as a fundamental right. We all know the saying, there's no point in doing something unless you do it right. And it's quite clear that the government needs to go back to the drawing board once again on some aspects of this legislation. Since there's not much evidence of them consulting Canadians on how their data was actually used. I believe the former Ontario Privacy Commissioner, Anne Kevorkian, said it best in 2020, under the initial Liberal attempts to bring in privacy reform to Canada, when she stated, and I quote, "The Liberals under the current Prime Minister have been extremely weak. They have not addressed repeated requests from the Federal Privacy Commissioner to strengthen existing privacy laws. I'm tired of that. I want a party that will walk the talk, and I'm hoping that will be the Conservatives," end quote. Madam Speaker, Canadians can count on the Conservative Party of Canada to walk the talk when it comes to strengthening our privacy laws. And Canadians can count on the Conservative Party of Canada to respect their freedom of expression online. We will scrap the online censorship legislation put in place by this tired, worn-out, costly coalition. We will allow people to choose for themselves which news they want to consume, not just what the government wants them to see. And under our new leader, we will be the voice of those left behind by this NDP Liberal government, and we will put Canadians back in the driver's seat of their own life. Thank you.
Questions and comments. The Honourable Member for Hamilton Mountain.
Thank you, Speaker. I find it interesting that the Canadian Conservative Party has become such a champion for big tech companies. And I'm wondering if the member opposite, since he brought it up, it's not related to this legislation, but if he thinks it's okay that Google blocked access to news to hundreds of thousands of Canadians in order to strong-arm the government. Does he think Google is a paragon of virtue that will, on its own, protect Canadians' privacy rights?
Member for Saskatoon West.
Well, thank you, Madam Speaker, and thank you for that question. So many things to say, where to begin. First of all, Google's one option. There are many other browsers that can be used. If you don't like one, you go to the other. That's the beauty of the free market and companies providing services. The other thing is Google's response was a direct response to this government's proposed legislation. The government refuses to admit that there are consequences to what they are proposing. There are significant consequences to the government dictating what consumers in Canada can see, and it'll affect everybody from the consumer themselves to the companies that provide that content. So it's just an example of the government being completely oblivious to the real implications of what they are proposing with their legislation, C11 and C18.
The Honourable Member for Drummond. Thank you, Madam Speaker. I was also astonished by what my colleague said about C11, and we can come back to that, but especially what he said about C18 with regard to news content. Being blocked for some 2 million Canadians. But what I heard in my colleague's speech is such a great amount of disinformation. What C18 does is oblige digital giants to negotiate agreements. We're not imposing anything on them. They have to negotiate agreements to ensure that content that they make money off of be paid for properly. So that seems to me simply logical. So really what bothered me in my colleague's speech is when he says that C18 is going to allow the government or the CRTC to decide what people are going to be able to look at in terms of online news. So I'd like him to tell me what specific article in C18 allows CRTC to do such a thing.
Thank you, Madam Speaker. We've talked a lot about C18, C11. There's been many comments come from people outside of this place, experts in the field. There have been lots of different things that have been said. And the reality is this. The government is going to have gatekeepers in place who will tell Canadians what they can see, what they can hear on the internet. And that is what we as Conservatives are fighting against. We do not want the government to be the ones to tell Canadians what they can see and what they can read online, and posting online as well.
Comments, the Honourable Member for Victoria.
Thank you, Madam Speaker. I want to thank the member for his speech. I also would love to hear his opinion. Right now, Bill C-27 doesn't explicitly apply to political parties, and we know there have been privacy breaches, misuse of data in the past in the political arena. And does the member think this kind of legislation should be amended to include political parties?
The Honourable Member for Saskatoon West.
Thank you, Madam Speaker, and thank you for that question. It's an interesting question. I think that's actually a good example of why this needs to go to committee to be studied. I think there are many questions that I've raised. Some of them other speakers have raised questions. These are things that need to be looked at committee. The committee is in a great place to call witnesses and to look further into some of these things. I believe that there's changes that need to be made to this legislation to improve it. And the member's suggestion is one possible way that it could be looked at. I think it should be looked at, but I think there are many more things that could be looked at, and I believe committee is the right place to do that.
Brief question from the Honourable Member for South Shore St. Margaret.
Thank you, Madam Speaker. I think it's ironic that the members of the Liberal Party, the government, are claiming some sort of aversion to big corporations. They haven't read the bill, obviously. Section 18.3 says an organization may collect or use an individual's personal information without their knowledge or consent if that collection or use is made for the purpose or an activity in which the organization has a legitimate interest that outweighs any potential adverse effect on the individual. This government doesn't believe in the protection of personal privacy. They believe in the protection of access to data for companies.
A very brief answer from the Honourable Member for Saskatoon West.
Summary of that I agree with is this government is mostly concerned about big business and their ability to use data. Conservatives are concerned about individual Canadians and their right to privacy protection.
Resuming debate, the Honourable Member for Edmonton Manning.
Thank you, Madam Speaker. Last week, the federal government banned the use of TikTok app on government devices because of data privacy concerns. It is very appropriate for us to be discussing this matter today. Digital data privacy can be seen as a fundamental right. One, they urgently requires strengthening legislation, protections and enforcements. Canadians must have the right to access and control collection, use, monitoring, retention, and disclosure of their personal data. This is a pressing issue, realizing that the European Union introduced a GDPR, which is the General Data Protection Regulation, in 2016. EU countries were given a couple of years to adapt to this new privacy reality. With the regulation coming into effect in 2018, the GDPR has been used by many other countries as a framework for privacy protection. While the GDPR, as an example, and faced with a changing digital data universe, this government basically did nothing to protect data privacy for Canadians. Perhaps that's an unfair statement. After all, digital and online data privacy was addressed in the last Parliament under Bill C-11. The Liberal did recognize that Canada needs to bring its privacy laws into the 21st century. But that bill was never passed. Apparently, data privacy was not a big enough issue to be made a priority, and the Digital Charter Implementation Act was scrapped in favor of an election that Canadians neither wanted nor needed. So now, we are asked once again to address this subject. It is indeed better late than ever. I would have hoped, though, that with the delay of the government could have improved on what they are proposing. Perhaps if this government had moved a little faster, Canadians would not have had to question how their data was being used, how their privacy was being invaded by governments and corporations. We are left to wonder how many privacy breaches have gone undetected or unreported. The ones we know of are disturbing already. Tim Hortons used their app to track customer movements. The RCMPs use Clearview AI's illegally created facial recognition database. TELUS gave customer location data to PHAC. It has been more than 20 years since Canada's existing digital privacy framework, the Personal Information Protection and Electronics Document Act, the PIPEDA, was passed. With technological changes in recent years, legislation is needed to address subjects such as biometrics and artificial intelligence. We have to consider how Canadians understand the issue of consent when it comes to the use of their data and their privacy. I'm deeply concerned and disappointed with how sloppy the Liberal approach in Bill C-27, the Digital Charter Implementation Act 2022, currently is. Privacy is a fundamental right. This bill does not mention that, despite the Supreme Court of Canada having acknowledged it. We need to clearly distinguish the extent to which Canadians' digital privacy will be protected. If the government wants this bill to be fully effective, it needs to further explore the scope of accountability required when privacy is breached. The clear definition of consent is a major improvement from what it once was in the Personal Information Protection and Electronics Document Act. But a good definition is only the beginning, because technology has greatly expanded and evolved since the implementation of PIPEDA. Should we not also expand the umbrella of activities that consent would cover? The large number of exemptions allowed will weaken the impact of this legislation. C-27 may be a good beginning, but I had hoped for something better. It is sad that this bill's title is perhaps the strongest statement in this piece of legislation. And while the title gives some idea of what the legislation is all about, it is already dated. We are no longer in 2022, and the Liberals are once again falling behind. As parliamentarians, we know the power of words and the importance of speaking in a way that can be understood by those receiving the message. It is important that legislation can be understood. It is even more crucial that those bills we pass spell out exactly what we intend. Perhaps the most important part of any of those laws is the section that provide definitions. They need to be clear and comprehensible and not subject to different interpretations that weaken the intent of the legislation. Legislation that allows each person to provide own definition is problematic. Bill C-27 uses words such as significant impact or sensitive information, and I can't help to question what is covered by these vague terms. Madam Speaker, before the people of Edmonton Manning sent me to represent them in this House, I was a businessman. I understood the importance of safeguarding the personal information my customers entrusted to me and not abusing the trust. But as we have seen, some companies made unauthorized use of the information they gather to gain a competitive edge or for profit. With that in mind, there must be a balance between acceptable use of data by business and the fundamental protection of our privacy. It seems to me the balance is wrong in this bill, given the way it addresses user consent and use of collected information. The more I read C-27, which is 100 page plus, the more question I have. There is too much in it in need of clarification. Yes, there will be done when it goes to committee on after second reading by the government, could be presented a better bill to make committee work easier. I don't want to sound too negative. I know the Liberals mean well, even if they don't seem to be able to quite understand just how important digital privacy is to Canadians in the 21st century. I'm pleased, therefore, to see that they understand that sometimes mere words or scolding are not enough. It makes sense to me that the Privacy Commissioner will receive new powers to enforce violations of the Consumer Privacy Protection Act. That may be the most impactful change this legislation brings about. It's not enough to simply recommend perpetrators stop their violations. Any parent could tell you that consequences are needed if you want to ensure improved behavior. With the Privacy Commissioner finally being able to force violators to conform to the rules, I think we will see increased respect and better treatment of Canadians' personal information. The harsh financial penalties for non-compliance will be a powerful motivator. Given the amount of time the Liberals had before presenting Bill C-27, you have to ask why they haven't come up with a better bill. They have left me and all Canadians asking if they really understand what their own legislation is supposed to do. Does their Customer Privacy Protection Act, as proposed in this bill, do enough to properly protect Canadians' personal information? They had a chance to look at the EU GDPR and to see how well that works. Did they learn anything? Does this bill, C-27, improve the protection of Canadians' personal information, or are there so many exemptions for needing consent in sharing of personal information that words of this bill are meaningless? Does this legislation create proper protections for Canadians' biometric data? Given that no such a protection currently exists, perhaps we would be thankful that the subject is addressed at all. It is reasonable to exempt security agencies and departments such as CSE, CCSD, from AI regulations. How do we balance the privacy and security concerns? Canadian digital privacy and data need to be properly protected. This bill is a flawed attempt to start the long overdue overhaul of Canada's digital privacy framework. Conservatives will be looking at putting forward some common sense amendments at the committee stage to ensure that this is the best possible legislation that we need to see. Thank you, Madam Speaker.
Questions and comments. Questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, Madam Speaker, I'd like to go to the principle of the legislation in which the member just said himself that he would like to see a series of amendments brought to it at the committee stage. Would the member not concede that if the bill does not pass through, he'll never have the opportunity to be able to propose those amendments, but he would in essence be sabotaging what I believe is legislation that is substantive, that is there to protect privacy of Canadians, and there are substantial financial consequences where there has been violations of this particular law that we are implementing. And I'm wondering if he could provide his thoughts on that.
For Edmonton Manning.
Throughout the two stages of two parliaments, this government killed the C-11 and they didn't see how important that just because they want to go to election. And now they're proposing a flawed bill and they're expecting us to say, yes, we will support it. We will support a bill that really makes sense, that a bill that is going to help, that bill is going to work for Canadians. I don't think we have any interest in wasting time, and it's up to the government to see what they're going to do with their bill, so to make it acceptable for other parties to support it.
Le député de Repentigny.
The Honourable Member for Repentigny. Thank you, Madam Speaker, and I'd like to thank my colleague from Edmonton Manning for his speech. At the very beginning, he said something that was very important to us, which is that in many cases, the personal information has already been compromised. It's already been compromised because the government was slack before enacting legislation. It took the European legislation to push this government in the back to come up with C-27. But C-27 has nothing to protect people whose privacy has already been violated. So would my colleague from Edmonton Manning have anything useful to contribute in that regard? The Honourable Member for Edmonton Manning.
Well, I did mention the European law that this government was too late to even look at and consider to follow steps so they can bring to Canada and Canadians some legislative piece, some piece of legislation that is going to help and is most needed. And I did mention one thing. There's a lot of vague definitions out there that is going to leave a lot of problems for this bill to be resolved. I mean, we can only hope that the government, when they present bill late enough, after years of this, it was like 2016 the Europeans presented their bill. We're talking 2023 now. They could have done something much faster and quicker and more mature, so we can together work to provide Canadians something that most needed.
Questions and comments? The Honourable Member for Victoria.
Thank you, Madam Speaker, and I want to thank the member for his speech. I want to thank him for the recommendations around the many amendments that are needed to strengthen this bill. One of them in particular that I'm interested in is around empowering the Privacy Commissioner, and we know that this is essential if we want to protect the rights of Canadians. One way to do that would be to equip the Privacy Commissioner with the power to seek the imposition of administrative monetary penalties in a manner that's similar to the powers that the Commissioner for Competition has under the Competition Act. And just wanted the member to kind of elaborate on how we must empower the Privacy Commissioner, ensure that he has the powers to enforce Canadians' privacy rights, and in particular on this issue, if he agrees that we need to amend this legislation.
The member for Edmonton Manning.
Thanks for the honourable member for her questions. I go back to the one thing I mentioned. I think even these vague definitions, they're still in the hand of the minister to decide after the fact. And that's one of the biggest flaws in this bill, where we don't understand how the minister is going to handle this and whether the minister will let the commissioners play their role and do their job. So that's why I think we have to be very careful approaching this bill and examining it, and especially on committee to be able to bring an acceptable and effective piece of legislation.
Very, very brief question from the Honourable Member for Kitchener Centre.
Thank you, Madam Speaker. As it stands now, federal laws do not require federal political parties to follow the same privacy laws that apply to others across the country. This is an issue that could have been identified and addressed in C-27 and hasn't been. I wonder if the member for Edmonton Manning has a position on this and would like to comment on it. Thank you.
For Edmonton Manning, very short answer.
Thanks for the honourable member on his question. I did actually edge on the where the federal provincial responsibilities comes on certain aspects of privacy and privacy protection. And again, the definitions comes to play here in understanding this piece of legislation. That's why the government could have done much better in bringing more clarity to the bill, so we can at least study it better. Thank you.
Resuming debate, the Honourable Member for Prince George, Peace River, Northern Rockies.
Right on. Nailed it, Madam Speaker, so thank you. We're here today to talk about Bill C-27, and it's got a big fancy name. It's an act to enact the Consumer Privacy and Protection Act. I worked on this extensively as former chair of the Access to Information Privacy and Ethics Committee. A big part of what we talked about was Canadians' privacy. But I want to lead off with a question I think that all are watching here. Many probably want an answer to this by the end of what I've said, and I hope I get there, is can we trust this government when it comes to privacy? And I'll lead off with, we've heard many accounts. We've heard foreign interference. We've seen evidence where that's been happening under this government. Ethics breaches, we can't even keep track of them all. But a most recent article, this is about Canadians' data. It's a National Post article, and many folks out there would remember this. Canada's Public Health Agency admits it tracked 33 million mobile devices during the lockdown. The Public Health Agency of Canada accessed data such as cell tower location to monitor people's activity during the lockdown, it said. So, can you trust this government? I think the answer is becoming more and more clear. But what have we done to protect consumer privacy? I was, again, part of that ethics committee. We formed an international grand committee, 9 countries, 500 million people, where we really tried to tackle and get to some better practices for big tech, because big tech is, Cambridge Analytica was a scandal that big tech was getting your information, many points, 53,000 points of information isn't what we had heard is the Facebook average amount they're collecting on you. And it's being sold to the highest bidder, and used not to just give you a choice on what cereal you should buy in the morning, but actually surveil you to make predictive behavior, so you'll kind of go in the direction that they'll want you to go. So we Conservatives saw a need to have a better, robust policy. So I'm reading from our Constitution. our policy that I was part of drafting with many other EDAs across the country. This is from the Conservative Party. The Conservative Party believes digital data privacy is a fundamental right that urgently requires strengthened legislation, protections, and enforcement. Canadians must have the right to access and control collection, use, monitoring, retention, and disclosure of their personal data. International violations should receive enforcement assistance from the Canadian government. So that is just a little snapshot about what we've been doing over here. And I guess we would hope that legislation like this would address some of those privacy concerns, but what we've learned, and many are hearing from this debate, there's huge exemptions for big tech. Huge ways to use consumer data in ways that they don't, first of all, don't want their information to be used and don't even know how their information is being used. So I'm going to get into some of the critics about Bill C-27. I'm reading from an article today by a young man, Brian Short, who has some concerns around Bill C-27. And I'll read. This change, and again, this is what Bill C-27 is proposing. This change opens the door for companies to begin describing their data collection and surveillance practices in a highly simplified manner, leaving out important details about how this information could be used to harm and discriminate against a person or a group of people, and ensuring that the data broker economy continues to thrive while people in Canada's privacy rights are pushed to the side. Well, according to the Liberals, this is what this bill is supposed to address. And here we see, simplified consent, that's something that we've supported too. It should be something that you can understand, but not to be abused in this manner, where there's a real consent, the fine print is down here, and you just check that little box, and it makes you feel good that you've done it. You feel like your data is protected, or your privacy, but it really isn't. And I'll read on. But with deceptive design practices already being regularly used to encourage people to click to agree without really understanding what they're signing up for, Bill C-27's weakening of consent could be a big step backwards in terms of privacy. So, again, I'll keep reading. I have a little bit more from this particular author. And we talk about the right to request deletion, and that's part of your data that's online. Again, in reference to C-27, what's lacking is a mechanism for when people change their mind about consenting to the collection of their use of their personal information, or if they're opposed to the use of their data and consent that wasn't required at all. So I think, again, we've seen the exemptions. They're a big haul. My colleague from Edmonton just referred to those exemptions. We want some better piece of legislation. I applaud the effort. The Privacy Commissioner, previous Commissioner Tarian, was excellent at just about really caring about Canadians' data and really pursuing a solution for it, really, defending Canadians, and I applaud him for that. But I'm going to go on to another critic that I've gotten to know very well from being on the committee, and his work in terms of Canadian information and how important that is to protect. A man named Jim Balsillie, a stranger to none of us in this place, former part owner of BlackBerry. I'll read the article. Globe and Mail, privacy is central to human well-being, democracy, and a vibrant economy. So why won't the Liberal government take it seriously? And so I'll read, and this is from Mr. Balsillie. Privacy is a fundamental human right, and we absolutely agree, that serves as a gateway to other rights and freedoms such as freedom of expression, individual and collective autonomy, and freedom from harassment or invasion. Privacy is critical for the healthy development of the human brain identity, close relationships, and social existence. True realization of freedom, that is, a life led autonomously, is only possible in conditions where privacy is protected. And I'll go on. It helps explain what he's referring to in that paragraph. Behavioral monitoring, analysis, and targeting are no longer restricted to unscrupulous social media companies, but have spread across all sectors of the economy, including retail, finance, telecommunications, healthcare, entertainment, education, transportation, and others. And I think one example, I've told many high school classes, and what's an example of this, An example, what we learned is the data is your data is being monitored in real time. So when you're standing in front of a display at a big box store, they know that you happen to be standing in front of a certain brand of headphones. And so don't be surprised if you get an ad before you leave the store of this particular headphone and why you should buy it. It's incredible. In some ways, it's in a good way, it's incredible, but it's scary in other ways too, in the predictive nature of having all that information. And he goes on to criticize the current Liberal government. Yet, Canada's federal government has repeatedly failed to take privacy seriously and construct a legal and regulatory framework that protects the rights of Canadians in the digital age. The Digital Charter Implementation Act, which is what we're talking about, normalizes and expands surveillance, Madam Speaker. Doesn't reduce it. Normalizes and expands surveillance and treats privacy as an obstacle to corporate profits, not as a fundamental right or even a right to effective consumer protection. And after years of cozying up to big tech and meeting with its lobbyists as often as twice a week, the Canadian Liberal government is finally coming to terms with the fact that the digital economy needs to be regulated. And time is short, Madam Speaker. But again, I asked initially, can Canadians trust this Liberal government? Well, they're pretty close to these guys, to big tech. And I'll use the example, and many have been talking out there about smart cities. Well, that conversation has been brought up many years ago, and so as recently as just a few years ago. And it was our efforts at Ethics Committee to really push back about this invasion of privacy that particular smart city in Toronto, Sidewalk Labs, would have as an invasion of Canadians' information. It was a complete Sidewalk Labs project, would monitor data on many levels. And so again, and its connections to this current Liberal government. So I'll read from an article. Sidewalk Labs project gained support from Trudeau in 2017, call ahead above the bid process.
Member knows we cannot use names of current members. Thank you.
Apologies, Madam Speaker, it's a title, but it's my mistake. But I think what's concerning about this particular article was that it's not just that the Prime Minister supports an invasive smart city kind of concept, monitoring everything, but it was done in secret. So the people that really wanted to get to the bottom of this Prime Minister and the conversation he had with Google and Alphabet, they had to get a Freedom of Information request to find out that this government was having secret negotiations behind the scenes. So, Madam Speaker, my time is up, but I started off asking a question: can we trust this Liberal government when it comes to privacy? I think the answer is a clear no.
Questions and comments. The Honourable Member for Hamilton Mountain.
Thank you, Speaker. And thank you to my colleague opposite for his intervention. I wonder if he doesn't trust this government, does he trust Google to make the rules and follow their own rules and to protect Canadians' privacy that way?
For Prince George, Peace River, Northern Rockies.
That is a very interesting question coming from a Liberal member across the way. No, I do not. And this is the reason why we were tackling big tech. It was Facebook, Google, you name them. The invasiveness of big tech on our privacy and our data is a huge concern. And the fact that Google was so linked with this current Liberal government and the former member Vaughan, and him carrying the water for Sidewalk Labs, it was really something else. And to see secret conversations going along to kind of usher this project through, and that was a Google project, absolutely I don't.
Questions and comments, questions et commentaires. The Honourable Member for Windsor West.
Thank you, Madam Speaker, and thanks for my colleague for his intervention. As he's aware, this bill is actually 3 bills packaged into one, and it was the NDP that asked for a separate division to vote on artificial intelligence. The previous manifestations of Bill C-11 were enhanced with this bill. But I'm wondering what his thoughts are in the mere fact that this is the first time that we're even debating or talking about how to regulate artificial intelligence, whether it would have been more appropriate to have that an entire separate process as opposed to packaged with two other pieces of legislation that we had actually done before and at least had some review in this chamber and are less controversial in many respects. And I appreciate his comments and thank him for referencing Jim Balsillie, who's actually done a tremendous amount of work on this issue and protecting Canadian privacy rights, which is the same. And then the NDP, it should be physical rights and your digital rights should be equal. Thank you, Madam Speaker.
Member for Prince George, Peace River, Northern Rockies.
Thank you, Madam Speaker, and to the member for the question. Yes, we absolutely support it being separated out. It's such a big issue to tackle that we should really tackle these things individually. They're absolutely huge issues. Just as a testament to in ethics, when we worked across the aisle, we often don't agree on things in this place, but the one thing we agreed on in our ethics committee, we all cared about our privacy and Canadians' data. It was the Liberals across the way. There was a couple of members that were supportive of where we were going. But I think in the efforts of supporting all Canadians' privacy and the right to privacy and not be, our data sold and farmed out to the highest bidder, I think it's in our best interest to defend all Canadians' privacy in this place.
The
Honourable Member for Beauport-Limoilou. Thank you, Madam Speaker. I agree with my colleague on some matters, including concerns about privacy protection. In fact, it really, really gets on my nerves when I see something, when I look at something online, and all of a sudden I'm flooded with ads that I didn't want to see. So we do need to legislate. But here's my question. We do need a digital charter. Our private data needs to be better protected. Does the colleague agree that it would be better to send this to committee, to conduct a thorough study, hear all the necessary experts in order to fully improve the bill, in order to ensure that there are no issues with it? Thank you.
Peace River, Northern Rockies.
Yeah, it's a good question. And I think the more alarming part, we get all those pop-ups and they mysteriously show up after we've been in a certain place. And then even extrapolate that to where people, we've heard from testimony at committee, where people, these data farms and data mining operations know how you're going to vote before you even know how you're going to vote. And then, and that's what leads us to huge concerns around being guided in certain directions to vote. And it's really very anti-democratic. We believe, Madam Speaker, that we need this bill needs to go back and get rewritten and done right. We have the expertise in this place. The Minister across the way just needs to listen.
A very, very, very brief question from the Honourable Member for South Shore St. Margaret, but really very brief.
Mentioned before, we've talked about legitimate interest being an exception of the business being able to use data without permission. Another provision in the Act, actually 15.5, gives the business the ability to do implied consent, which is really consent without consent. So I wonder if you comment again how the Liberals are in the pocket of big tech on that.
The Honourable Member knows that. I won't be commenting on anything. And the Honourable Member for Peace River, Northern Rockies, very quickly.
Yeah, and the evidence that this government's been in the back pocket of big tech, it's been there since the member across the way, Member Vaughan, he's not here anymore, but it was just so obvious supporting Google and all its ambitions. No, I think what we need to do, we all understand that there's interest where data is something that we need to use, but it needs to be done with privacy.
And we do have to resume debate. The Honourable Member for Cypress Hills Grasslands.
Thank you very much, Madam Speaker. It's an honor to rise once again in this place as we resume debate on Bill C-27, which is the Digital Charter Implementation Act. For any discussion of this bill and related issues, we are not going to get anywhere if we do not start with recognizing that privacy is a fundamental right. This is what Conservatives believe and where we're coming from when we talk about the positive or negative aspects of this piece of legislation. Not only is it true, but it has to be a priority. That is what Canadians expect from us, and that is the message we are delivering to this government. It's also what has been echoed by many of our constituents as we get our emails, we get our phone calls from people who are concerned about this bill and about this issue in general as well. The world we live in is rapidly changing, and the pace of change seems to be getting faster as we go. It's really amazing what people can achieve with digital technology, And yet, it has also left us in a more vulnerable and insecure position. There are many ways of intrusions and violations of our privacy which did not exist before. And it's safe to say that this trend will continue in the coming years. If it wasn't clear already, it's easy to see now that we have to do more than respond to the changes simply as they come. Instead, we need to do our absolute best to think ahead and make sure that our effort to protect privacy will not become outdated shortly after we pass any kind of bill into law. It's the least we can do if we're serious about preparing our country for the future. But before we can do that, Madam Speaker, it's true that we first have some catching up to do. Our current privacy legislation is long overdue for an update. It's been 22 years since Canada updated its privacy legislation. 22 years ago, the internet was basically a new phenomenon, and only about half of Canadians were online. 22 years ago, I think it was Joe Sakic was the MVP of the NHL, and I was only 13 years old. So a lot has changed in that time frame, Madam Speaker. Today, the internet's a valuable tool used daily by the majority of Canadians. Generally speaking, people basically are living online. We use social media to connect with families, to connect with our friends, and professional networks. We use GPS to get directions to move from place to place to navigate around our cities and towns. We have online banking to manage our finances. But at the beginning of the new millennium, pretty much the majority of this was unheard of. And in fact, I think we can all remember what we all thought was going to potentially happen on Y2K and what the implications that was going to maybe have on technology, which thankfully never came to fruition. And as we speak, it has been years since the Liberals announced the new data strategy for Canada, and it also hasn't become a reality. That promise also came 4 years after they formed government. It has now been about as long from then until now. And after such a long time, Canadians are still waiting for someone to provide higher standards with the use and collection of their personal data. So much of what we do these days involves an exchange of our data. There's facial and fingerprint recognition used for security along with our passwords. Digital maps and search functions track our location in real time. Many of us upload and share an overwhelming amount of personal information onto social media accounts and platforms. We're constantly giving our data to different online companies in order to use their services. People feel comfortable enough to do all of this because there is a voluntary loss of privacy for the sake of convenience. But this arrangement also requires a deep level of trust. It could not exist otherwise. And whenever there has been a breach or loss of that trust, the problem of privacy becomes more obvious. There have been organizations exploiting people's trust to sell their personal information without authorization. In some cases, the data has gone to places which are not working for their best interests. And I'm sure, Madam Speaker, you, like many people in this House, when you go to a website, it asks you if you accept the cookies. For example, people just hit accept and go on with it, right? I want to read the article. What they don't realize is what they are agreeing to when it talks about what is going to happen with their search history or different aspects that might be invaded by those cookies. So we have to get serious about privacy, and we have to mean it when we say that we recognize privacy is a fundamental right. The first draft of C-27 says this in the preamble, and I'll quote, "The protection of the privacy interests of individuals with respect to their personal information is essential to individual autonomy and dignity and to the full enjoyment of fundamental rights and freedoms in Canada," end quote. Of course, I'm not going to disagree with that. I believe it is good for our law to make a statement like this. However, Madam Speaker, it is also true that we can and should take it a step further in the same direction. Why not have this type of statement included in the text of the bill instead of only in the preamble? That way, it would be more likely to be stronger for enforcement and interpretation by the courts. With the situation that we are in today, it's worth making our privacy law as strong as possible, and this would be a simple way for us to set the right tone. That is something which we are calling for. This is one example among many for how C-27 could be improved with some amendments. Conservatives want to make sure that we update our legislation in the right way. After all, in this area of privacy, we should not settle for less. There is more that can be done to fill the gaps in our privacy law. If the government does not accept stronger legislation, it will simply be insufficient. The law must ensure that the privacy of our citizens will be respected by the activities of government and business. Canadians are the owners of their data, and corporations should ask for consent if ever they hope to collect, use, or disclose a client's information. But instead, this Liberal government still has loopholes for privacy. Corporations can still operate with implied consent instead of express consent, which is freely given, specific, informed, and unambiguous consent. What happened with Home Depot and Facebook shows how relying on implied consent can go wrong. In this case, someone could ask for an email receipt from Home Depot. Their email addresses as well as their purchase were given to Meta, which then matched the person with a Facebook or Instagram account. When brought to court, Home Depot claimed that they had the implied consent of the customer to share their email with whomever they pleased. And I know that when I shopped at Home Depot, I never did give out my email address to them, but they never once asked me if I was okay with sharing that data with somebody other than for their own transactional purposes. We have a lack of clarity, which is not protecting the consumer as much as they should be. Implied consent has been losing relevance over time. In our context, it creates headaches for customers who are going about their regular business. They expect one thing and later find out that something much different is going on with their personal data. Even if they agreed or simply went along with something, they rightly feel misled by what happened. And that is not informed consent. Our peer countries have been moving away from this. Europe's general data protection regulation has been heralded as the gold standard for privacy laws, and it has done away with implied consent. Going back to Home Depot, they also said that anything you bought there would be classified as non-sensitive, which is something this bill fails to define. Vague language will not favor our citizens in the end. With the Home Depot case, we can see that the law could be interpreted by larger organizations to allow them to do what the law actually intended to restrict. We should clearly define sensitive information, and it needs to apply to everyone. Another vague part of this bill is the implementation of the right to disposal. C-27 allows the user to request that their data be destroyed, but clarification is needed regarding anonymization and the right to delete or the right to vanish. At the end of the day, this bill is like many announcements the Liberal government likes to make. It sounds good, but the incompetence, the vague language, and failure to close loopholes mean that it will not do what they say that it actually will do. But this should not surprise anybody if a Liberal bill has significant weaknesses and gaps for the issue of privacy. It's hard for Canadians to take them seriously based on their own record. They have not shown respect for privacy. We have seen a government agency use location data from cell phones for tracking purposes. We have seen law enforcement access Clearview AI's illegally created facial recognition database. And of course, last year we saw the public doxing of online donors. While that was happening, the Liberals decided to mess with the bank accounts of Canadians. And some of those peoples had not even made donations themselves and certainly had not committed a crime. It is easy for things to go wrong when there is government overreach. But today, Madam Speaker, the federal government has an opportunity to modernize and protect our country for the problems we face in the 21st century. If they don't listen to us and they fail to make the right decisions, it would be truly shameful. Thank you very much.
Questions and comments? Questions et commentaires? The Honourable Member, Parliamentary Secretary of the Government House Leader.
Thank you, Madam Speaker. I'm wondering if the member can enlighten us in terms of why it is, the member makes reference to what he believes is shortfalls of the legislation. If he can indicate clearly, does he have specific changes that he would like to see take in the form of an amendment that he believes would enhance the legislation to the degree in which the member would be prepared to support it?
The Honourable Member for Cypress Hills Grasslands.
Well, I think a lot of it, too, falls on the vague language that we see all throughout the bill. I alluded to that multiple times throughout my speech. And, I think Canadians, they want to see strong safeguards because right now, just the fact that there's not as much protections currently in the law, but as this one is currently written, it's not going to necessarily strengthen that either. I mean, it's good to see that the government's put legislation forward, but at this point, it just feels like it's a virtue signal that, we're going to take this issue seriously, but they're not actually doing anything substantive to it. So we want to see them, first of all, have stronger language to actually make sure there are real rules in place to protect people's data and make sure that they're not going to be victimized either by big government or by big business.
Questions and comments? The Honourable Member for Drummond. Thank you, Madam Speaker. I'm wondering, we're talking about the anonymity of data and the importance of keeping private information confidential and anonymized. But soon we're going to be working on hate speech and online hate speech. And for me, it's essential that internets should be able to be traceable so that we can legislate and intervene if we see hate speech online. that could even be criminal. So does my colleague think that there might be a possibility of protecting personal data by anonymizing them, but also protecting the safety of Canadians and Quebecers by ensuring that internauts are traceable in terms of crimes committed online?
Yeah, well, I think anonymizing and aggregating data is extremely important. You know, one such example that we saw where that wasn't necessarily taking case was with Tim Hortons a couple of years ago. They were using your, if you had the app and you're going to the store to either buy a product or just if you just had it on your phone, you went through there, they would track where people were going for a period of time after they had been at the store. And it was very clear where that data was going, where it was going to be used for, because it was not anonymized or not aggregated. So I do think that there is something to be said for having a proper regime in place to make sure anonymization, aggregation happens and takes place. It does happen in some cases, but I do think it does need to be utilized a lot more in cases where people's data is there. But people need to know for sure and have the absolute confidence that it will be done and it can't be unscrambled, because we've heard many times in other committees where that unscrambling of data can happen, and it can happen quite quickly too. So we need to make sure people are protected even if they are being anonymized and aggregated.
Questions and comments? The honourable member for Windsor West.
Thank you, Madam Chair, and thank you to my colleague. I think one of the things that we've really benefited from in Canada is the Privacy Commissioner and the office. There's no doubt the United States not having this position has created an issue for them, but for ourselves, the independents and the Commission having appropriate resources and reformation to enforce the decisions and independence from Parliament in many respects is important and crucial for the NDP. Just wondering where the Conservatives stand on this with regards to the Privacy Commission, because there will be a tribunal potentially created to this, and then there will be far more regulation and oversight necessary from the Privacy Commissioner in the age of artificial intelligence.
Answer from the member for Cypress Hills Grasslands. There's 45 seconds left.
45 seconds left. Okay, thank you very much, Madam Speaker. Yeah, having the Privacy Commissioner is fantastic, and it's interesting to see other provinces that have their own privacy commissioners as well too. You know, for a number of meetings, I subbed in on the Ethics Committee, and we heard from some of the provincial privacy commissioners that were doing they did fantastic work. They did important work. I think, generally speaking, Canadians would like to see them continue to be able to do their work. So, they play an important role. So I'm only going to talk about what's happening here in Canada, but I'd like to see their offices continue to function. And I appreciate the valuable work that they do. And
Reprise de débat.
Resuming debate. The honourable member for Beauport, Côte-de-Beaupré, Île d'Orléans, Charlevoix. Courage, Madam Speaker, courage. Thank you very much, Madam Speaker. An act to amend the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act, and to make consequential and related amendments to other acts. Madam Speaker, this title is very long, and it equals the amount of work that will have to be put in by legislators. Because, you know, Quebec is already ahead on this, but we need to send C-27 to committee in order to invite experts who will be able to show us the flaws of this bill and shed light on how we can improve it. There are too many details in the perspective in terms of fields of intervention, and we can't see them all quickly. It is not specific enough, but that's normal. For the committee will require a number of witnesses, and so this bill should not be adopted or should not be rammed through. We need to take our time in committee. That means taking responsibility if we want to empower internauts themselves. The House Speaker decided that C27 would be submitted to 2 votes. The first will be on Parts 1 and 2, including the schedule to Section 2, and the second will be on Part 3 of the bill. This means that if the House votes against the part on artificial intelligence, work on C27 will continue without the part on artificial intelligence. If it votes in favor, the bill will go to the committee as a whole. Now, even if we vote for the part on artificial intelligence at second reading, we will be able to vote against it at third reading. We need this type of leeway. PIPEDA has required reform for many, many years. And so it is pressing that we adopt a digital charter. The Canadian PIPEDA is from a pre-digital era, and even I might say a prehistoric era, because the context we are in now is completely different from 2000. C27, it also comes as a response to the General Data Protection Regulation, that is a strict way of protecting personal data. Without an adequate legislative response, we already know that it will be impossible for European organizations to exchange information with countries or international organizations abroad that do not have a legislation that is as strict as theirs. Therefore, without C27, a good bill, then Canada will not be able to meet the requirements of the EU, and I find it very important and a very serious matter. So in Canada, the financial field is worried and is pressuring the government because it doesn't want to lose its European market. Now, in Quebec, this pressure is not as high because we already have a good bill. But the problem is with duplication and overlapping. For example, Mouvement Desjardins is already ready, but not Desjardins Trust, which is in Ontario. And that's the former Trust Royal. So it's quite concerning that Ontario does not have an updated piece of legislation that protects personal data and artificial intelligence. And that there is not a uniform type of legislation. Now, this is a pressing matter, but we have to do this in an organized manner to ensure that the essence of this bill is protected. Now, with regard to individual protection, C27 defends the anonymity of individuals. It focuses on the individual and the idea of consent with regard to digital exchange, whereas to date in Canada, organizations have benefited from a free ride and from digital chaos to communicate information, personal information, without any kind of punishment. So now C27 provides guidelines and restricts this type of freedom, but it also it imposes responsibility. C27 creates a tribunal as well. Now, there are 3 types of punishment for people who do not comply. So we're talking about administrative monetary penalties, criminal offenses, and prison offenses. So C27 really has teeth. Now, the protection of personal data is a shared jurisdiction, and even if C27 gives the impression that it will respect Quebec's Bill 25 on the protection of personal data, it doesn't really offer any real guarantee of that. So the government must ensure and edict that Bill 25 is similar to C27. Now, C27 is not supposed to take precedence over the Quebec legislation, and this has to be confirmed in committee. Now, let's talk about artificial intelligence. For example, individual identification. There are currently 3 types of individual identification. So social insurance numbers, passwords, there's also biometric data, vocal recognition, and texts and phone calls. Now, right now, the European law says that businesses have to use 2 of these formats. So C27 has to legislate on that as well. Another variable is that of sensitive personal data, which is inspired by European law. And Bill 25 defines such data, sensitive data, by saying that by its nature or reason, in the context of its use, it may breach private data. Now, even if C27 does not define what sensitive data is, we need to specify in terms of cybersecurity measures. Now, there's also this bill will have to underpin more ambitious laws that will adequately regulate artificial intelligence. But this is a good start, although their government is coming late to the game. Let's talk about what artificial intelligence can do. It imitates human intelligence that is based on the creation of the application of algorithms that are applied in a dynamic computer environment. We all saw the Prime Minister in a fake interview saying fake things, and the audiovisual was very deceptive. It looked just like him. We have also seen that artificial intelligence can create works of art that are very similar to existing and real works of art. For example, through the new ChatGPT, different of the various 80 songs that I have written could be combined to make an 81st one that would have the same melody and the same type of metaphors. So I find that quite concerning. We have all understood the scope that this type of exercise can take and the impacts that it can have. However, we have also learned from science that in a legislative framework that is adapted to current realities of AI, it will be able to put in place more foreseeability, and so this work tool could be revolutionary. What is worrying us, though, is that the minister has mentioned that this bill should be pushed through swiftly, but the Bloc believes that we need to take the time in committee to hear from different witnesses who will be able to inform us on any flaws in this bill. Now, the government has said that it is open to that, so we'll see if it answers our requests. We certainly hope so, and if it happens like that, that will be good news. Artificial intelligence is more linked to the process and the capacity of reflection and analysis of data rather than a format. So we have to deal with this notion carefully and understand its impacts in order to create a proper legal framework. That is why it is so important to take the time required to study this in depth in committee. Once again, Quebec is ahead in this field, and we will be a good reference for this bill. Thank you.
Questions et commentaires. L'honorable député.
The honourable member for Acadie-Bathurst. Thank you, Madam Speaker. And I'd like to thank my colleague for her speech on Bill C-27. And I also appreciate her work in the Fisheries Committee. I have 3 young children, 7, 8, and 10, and they're often playing on their devices. And so I remember when I was a child, things were very different. So I'd like to ask my colleague whether she thinks that it's important to have protection for children in this bill, and whether parental control should be ensured so that we can protect our children from social media and from online problems. Thank you.
L'honorable député.
The honourable member for Beauport, Côte-de-Beaupré, Île-d'Orléans, Charlevoix. Thank you, Madam Speaker, and I'd like to thank my colleague. I also have great admiration and friendship for him because we work very closely together in committee, and we work very efficiently. And I'd also like to underscore that his wife is also a songwriter, so he knows what my worries about copyright and AI copying are all about. With regard to cybersecurity for children, of course, I have to agree with him. I think that the committee will be studying this particular component of the bill. Yesterday we talked about cyber violence. Thank you. Yes, cyber violence, and so I think that that component will be essential, and we will have to think about educating families, educating parents, so that they can have tools to better protect our children who will need it in this chaotic world of cyber activity.
Comments, questions et commentaires. The honourable member for Oshawa.
Thank you very much, Madam Speaker. And I want to thank my colleague for a very thoughtful speech. She's probably hearing from constituents as well as I am. The bill seems to be silent on the selling of personal data. It's silent on facial recognition. She mentioned the artificial intelligence part of it. It just seems that the new artificial intelligence part of it was just jammed alongside, not a lot of thought in there. But I was wondering, she didn't comment on a concept of implied consent, and I want to thank my Liberal colleague for bringing it up for protection issues. The bill does mention a term, implied consent, and that would allow businesses to take a user's consent to use their data and information for new purposes without actually obtaining it. I was wondering if she could actually comment on that and why it's so important to get that right.
The honourable member for Beauport, Côte de Beaupré, Île d'Orléans, Charlevoix. Thank you. I'd like to thank my colleague, Madam Speaker, for his good question. When it comes to consent, I think we need to raise the standards with very clear and specific rules to avoid any ambiguity. Because this bill that's why this bill needs so much study at committee. I think we could discover that consent is a very unique aspect of this field, and so we need very clear and specific guidelines and criteria that will actually hold up in practice. So hopefully the experts will be able to guide us around that so that we can we can hear from them at committee.
Thank you very much, Madam Speaker. I want to thank my honourable colleague for what I believe to be a good and important intervention. And it's an important piece to talk about because I think mega corporations, in particular those corporations that utilize AI and other digital tools, have been doing something nefarious. And that nefarious thing is putting these long, huge, giant legal descriptions that many people just scroll right to the bottom and accept, but many people don't know how complicated those arrangements are that they're coming into. And would the member talk about how dangerous it is to have such complicated agreements that regular folks are signing on to, not knowing the explicit dangers and damages that come along with agreeing to those terms and conditions, like the ones we're talking about today, like the ones harvesting data. Would the member expand on that, please?
Bref réponse, l'honorable.
A brief answer, the honourable member for Beauport. Brief answer. On a pack of cigarettes, it says danger causes cancer. I think we should do the same thing when it comes to the security of our personal information on the internet.
Resuming debate, the honourable member Calgary Rocky Ridge.
Thank you, Madam Speaker. So privacy is important, and on this I think nearly all Canadians agree. I presume that all members of this House agree as well. A generation ago, the Supreme Court also agreed. It said that privacy was something upon which our most basic and ancient expectations of liberty depend. The security of the person depends on privacy, and without a basic expectation of privacy, it's difficult to imagine how any freedoms and security can exist. So, what about privacy in the digital age? There's a growing awareness of how both businesses and governments threaten people's privacy and their expectation of privacy. Over the last few years, Canadians have seen high-profile examples of gross violations of this basic expectation of privacy, both from the private sector and also by government. Users of the Tim Hortons app were rightly appalled when they learned that a private business was tracking their movements well after they had ordered and purchased their products without their knowledge or consent. We heard about Home Depot and the sharing of emails without the knowledge or consent of their customers. We've seen here where TELUS Mobility gave the Public Health Agency the mobility data of not only their own customers, but any customers whose signals pass through their infrastructure without following the requirements of Canada's existing privacy laws, which required the Public Health Agency to consult with the Privacy Commissioner before using the data and obtaining that data. We've seen a private corporation, Clearview Artificial Intelligence, Clearview AI, who had a business or have a business where they scrape billions of images of people's faces from across the internet. They identify these images however they can from whatever sources, public or whatnot, that they have, and then sell these identified images to law enforcement agencies without the consent of the people whose faces and identities they sell. So these are examples of how both public and private institutions flout existing laws. And we've seen how on the public side, how the privacy commissioner has been ignored. When knowledge of PHAC's use of their, or actually when both PHAC and the RCMP, when knowledge of what they had done became available, it was clear that they had not followed the existing laws and consulted with the privacy commissioner. The RCMP, in fact, even disputed the findings of the privacy commissioner. They treated the privacy commissioner's findings that they had violated the act. They considered that finding like it was some kind of matter of opinion with which they could disagree, and even repeated that refusal to accept the findings of the privacy commissioner at a parliamentary committee. So we've got a real problem with both businesses and with the government, who don't take their obligations to Canadians' privacy seriously enough. The RCMP also used sophisticated spyware to hack cell phones, again, without consulting the privacy commissioner about the use of new technology and new investigative tools, which was required under existing law. So this government has a problem when it, with respecting Canadians' privacy, and it's got a credibility problem around privacy-related issues, Madam Speaker. So in addition to these well-known breaches by law enforcement and law enforcement's casual attitude towards compliance with privacy law, the commercial incentives for business to use new technologies like facial recognition with artificial intelligence, there are enormous commercial incentives for businesses. And these concerns have we've studied them at parliamentary committees, and we've heard experts testify about the dangers to Canadians by the potential misuse of artificial intelligence, both by businesses and by law enforcement. I mean, what happens when artificial intelligence goes wrong? I mean, facial recognition technology has built-in biases. We've heard expert testimony about how the efficacy of facial recognition under existing software is best with sort of middle-aged white male faces, that when an individual is a child or a senior or a woman or a person with a darker skin tone, that these applications are far less likely to correctly match people. And that has life-changing consequences when we're talking about law enforcement, Madam Speaker. Never mind all of the commercial applications potentially with AI, with retail and other potential users. So all of these, in facial recognition, the images are often scraped from the internet without the consent of the borrower, or of the consent of the consumer. But consent is obviously something, and a system of consent is completely broken with privacy, and this needs to be updated. And I know that this bill tries to address this, but we know how anybody that has a device, we all have these devices that are connected to the internet, and I think everybody in this chamber and most Canadians have had the experience of trying to obtain access to a new application or using a new device, and you are confronted with an incomprehensible set of policies and disclosures with an agree button at the bottom. So even people that actually would undertake the painstaking process of reading through one of these enormous statements will generally get to the bottom and conclude they don't really understand what they're getting into, but they need to proceed with whatever task is at hand, and they click agree. That's that's a very small number of people. Most people just clear to the bottom, get to the bottom, and hit the agree button. And nobody has any idea what they've agreed to. I think a lot of Canadians are sadly resigned to the belief that they know that when they click agree, they are giving up a part of their privacy. They don't really know what they're giving up. They know that they've given up something, but they just sort of shrug their shoulders and think there's just no way around it. There's no other alternative other than to hit the agree button. So I think there's no doubt that the consent model is thoroughly broken. And there's no doubt of the need to modernize Canada's privacy law. So does this bill cut it? Well, I would say no, Madam Speaker. This bill is too vague, it has too few details, and leaves too many unanswered questions to warrant support even as far as a committee study. This bill is a missed opportunity to get something right that has long been wrong. The failures of the existing privacy laws have been known for a very long time. This government's had a long time to get it right, and they have not done so. What we're debating is a bill that is consistently vague and has too many questions about it, what it does and what it fails to do. And furthermore, the concern is that if this bill passes, the number of these questions that will simply be settled by the minister and the department's bureaucrats rather than through parliamentary oversight. So this bill still doesn't definitively answer questions about when and how consent for the use of personal information is collected. It talks about the need for plain language, which, yes, of course, I agree with that, but it offers significant exceptions and no details. The bill doesn't clearly define a series of new terms, including sensitive information, as being distinct from other types of information. So while this bill, will this bill be compatible with the European Union's GDPR? There's a worldwide consensus that the GDPR is, some call it the gold standard. I don't know if it's really golden or not, but there is a consensus that it's sort of the best balance out there between balancing commercial expediency and consumer privacy. But we don't know if this bill is even going to meet up with. And how much time are we?
25 seconds.
Oh, I'm way behind then, Madam Speaker. I wanted to get into a number of shortcomings that this bill has, but if that's the case, I might have to get that in questions. But I'm not going to support it. It's not strong enough to warrant approval, even as far as a committee study, although I understand the need for a bill that will address privacy, and with that, I'll let the questions follow.
Questions and comments? Honourable Parliamentary Secretary, the Government House Leader.
Thank you. Madam Speaker, 20 years later, after the need to see changes, Bill C-27 is here. And, the last time we saw changes, Facebook didn't exist, iPhones didn't exist, and this is important legislation. Now, within the legislation, to use a couple of examples, there's a framework that allows for substantial fines. There's a framework that allows for protection of Canadian privacies. And what we're hearing from the Conservative Party, Madam Speaker, is that they don't want any of it, because they're going to vote against the bill. They're ultimately arguing that this bill is not amendable, that they're going to vote against it. And my question to the member is, does he not see any value of the substance that's actually there to protect Canadians and empower things such as substantial fines?
The honourable member of Calgary, Rocky Ridge.
Well, it's true that this bill contains the provision of substantial fines. Who is going to get fined in this bill? Who will it apply to? Will the tech giants, with their armies of lobbyists and lawyers, figure out the loopholes within all the ambiguity in this law? And will this be something that a small business owner who is not in the business of harvesting data but nevertheless must collect information to complete a transaction, will it just give a small business owner more red tape, more potential liability while letting off the tech giants? I don't know the answer to that question, and that should be clearer in this bill.
Questions et commentaires. L'honorable député de...
The honourable member for Trois-Rivières. Thank you, Madam Speaker.
I don't know if there's ventriloquism around, but l'honorable député...
The honourable member for Trois-Rivières.
On a encore un petit problème ici avec, je vais vérifier avec les greffiers pour qu'ils s'assurent que le micro est fermé. L'honorable...
The honourable member for Trois-Rivières.
C'est encore ça de l'affaire avec l'interprétation. On entend l'interprète dans la chambre. Essayer, là.
Okay, we'll try again. The honourable member for Trois-Rivières.
Il semble que l'interprète, je ne sais pas, pourtant je ne vois pas son micro être dessus, mais quand il fait l'interprétation, I guess, on va réessayer.
Let's try again. The honourable member for Trois-Rivières.
OK. Je vais laisser l'honorable député commencer.
I'll allow the member to begin.
Ça ne va pas fonctionner.
It's not going to work.
On va prendre une petite pause pour une...
We'll take a short break just to solve the problem.
No, we can hear the interpreter. OK, on va essayer de...
Okay, we're going to try again.
Non, ça ne fonctionne pas.
It's not working.
Il semble que le problème, c'est entre l'interprétation de français à anglais. Try again. On essaye encore.
Can the...
Try again. Test.
Non. On a encore le même problème. Ended by host. On réessaye une autre fois.
We're now testing again.
Non. Bonne journée. On a quelqu'un en route pour régler le problème, on espère?
Testing. Testing the English interpretation feed. Testing the English interpretation feed.
On va essayer un petit.
We are now testing again. We are trying it out. I'm being told that it's working now. Excellent.
Oh, I'm going to speak in English to make sure, but the problem was in the French language. Things seem to have been fixed. L'honorable député de Trois-Rivières.
The honourable member for Trois-Rivières. Thank you, Madam Speaker. I, like you, was surprised to hear voices in my head. Here's my question for my honourable colleague from Calgary-Rig, with whom I worked on the Ethics Committee. He is well aware of access to information issues. So here's a question. Now we have ChatGPT. So with ChatGPT, won't we just have to rewrite this bill because it will become obsolete with this major change in the reality, in the situation with access to information?
Well, that's an interesting question, and he may well be right. This bill certainly has a lot to catch up for. It's been, as has been pointed out, a long time since the existing law was updated, and yet it seems to me that so many questions remain unanswered about problems that have been well identified by all sides in this chamber, and yet not clearly and definitively solved by this bill. And the emergence of new technologies, while we're not even coping with some that have existed for years, is a problem. We're in the third decade of the internet age. I mean, a lot of this stuff is not new, and we're still catching up with decades of issues around privacy.
Questions and comments? A brief question. The honourable member for Windsor West.
Thank you, Madam Speaker. I'm just a little concerned with the Conservative position of not sending this to committee, which is industry and has a cooperative approach to trying to fix problems in bills, which we're currently doing now. And would like to know from the Conservatives what exactly it would take to at least move this to committee. I have a lot of concerns about the bill. There's many issues that we've raised and spoken to, but I think it's a fairly unfortunate position that we're going to leave it to Google and the internet giants to basically rule over uninstructed Canada for the next couple of years if we don't at least try to fix some of the problems that have been well identified.
Answer, the member for Calgary-Rocky Ridge.
Well, I think that if I was convinced that this bill would do no harm, at a minimum, perhaps I'd be inclined to send it to committee. I'm not sure of that. And sending a bill that has this many holes in it and this many items that need to be fixed, I'm not sure if that can be done at committee. I'm disappointed that the government didn't table a better bill.
Resuming debate, the honourable member for Calgary Centre.
Well, thank you, Madam Speaker, and I rise today to address this House on Bill 27, the Digital Charter Implementation Act 2022. So we're just a year behind or so. But 34 years ago, the Supreme Court of Canada recognized that privacy is at the heart of liberty. Much has changed since 1989, and little more drastically than the continuous transfer of the private information of Canadians to other organizations. The questions we need to ask are, what are the costs and what are the benefits of the availability of Canadians' private information for the use of others? Many organizations see themselves as supplying useful value to Canadians by being provided, whether by contract or by capture, private information that is not knowingly provided by citizens. Examples include service companies that recognize when a consumer might be able to save a percentage of their fees by bundling certain services. In such a case, the benefit of this information availability is shared by the consumer and the service provider. Make no mistake, what drives the action by the service provider is profit, what's known as the greater share of wallet. Nevertheless, in such cases, the consumer sees the benefit of being included in the information sharing, whether they know it has occurred or not. This apparently benign approach to gathering information has now stretched to our daily lives, where our computers, our phones, and our in-home private intelligent assistants, things like Siri and Alexa, are gathering information on us. When my sons at their homes use Siri, they say, "Siri, turn on." They figured out that Siri was listening the whole time. A lot of information is being culled. Do we know that our information, in that case, when we have not actually disclosed it willingly, is being used in a benign or creditable way? Which of that has become public information to be monetized by somebody else? And this is what is occurring. Large corporations are gathering data that is being sold to others for their own purposes. That supposedly benign relationship is now being passed to another organization, in that case, that is paying the information gatherer, and so on and so on. There is no accountability mechanism to the individual for the benefit of the supply of one's information to flow. There is only one measurement at play, and that is profit. One need only look at the incredible financial returns associated with these technological information gathering companies, the Googles, the Metas, the Amazons, etc., none of which are Canadian, by the way, and realize that the value extraction industry is lopsided in their favor. At no time in human history have startup companies, many without a tangible product, achieved such lofty valuations so quickly, and billionaires created out of computer code that is providing exactly what? Information. Our information. Value is created and destroyed in commercial markets. That is the economic engine that has led the Western world to prosperity. But value is only traded in financial markets. Let's ask, is the culling and selling of private information, however obtained, creating value or transferring value? In that respect, the intent of this bill is good. It is designed to modernize the protection of Canadians' digital privacy rights. It is past due, and it is important. It cannot be delayed by another prorogue parliament or another unnecessary election call, as happened to the prior bill that was introduced to advance this issue in the last parliament. The aim of this bill is good. The execution, I would say, is way off. I see a bureaucratic solution designed by bureaucrats for use by bureaucrats with what will be a minor effect for the Canadian population in general. As we say, if you are a hammer, everything looks like a nail. The design outcomes of this bill are increasingly bureaucratic oversight. The Personal Information and Data Protection Tribunal Act. 6 members being put together in a tribunal here, of which 3 will have experience in information and privacy law. Only 3 out of 6, so half are going to have experience in the very laws they're going to be overseeing here. This is going to be responsible for determining the severity of financial penalties. It'll have a staff of 20 with a budget, along with a larger budget for the Privacy Commissioner, which already exists. Does anybody see any redundancy in this solution? And there's a litany of financial penalties listed through this bill, and a host of requirements of all businesses, even small businesses, which are going to find the requirements of this bill onerous in the extreme. Joe's Garage is going to be treated with the same expectations as the Royal Bank. and face the same potential penalties. I want to read from this legislation something that would scare any small business person. This is about privacy management programs as required under the legislation. It states, every organization must implement a privacy management program that includes the organization's policies, practices, and procedures. It further states the organization must take into account the volume and sensitivity of the personal information under its control. What does that mean, and how do we interpret that? Further, an organization must ensure, by contract or otherwise, that the service provider provides substantially the same protection. So a businessman is going to have to ensure something nebulous is not being provided by their service provider when forwarding information. Clearly, no one involved in this bill's design has even considered what this means for Canada's small business community. Here's the issue for Canadians. Who has the most information on Canadians? Well, governments, first of all. Who is likely to get information hacked? Those same governments. This bill shows a complete lack of accountability for the government about how it might misplace or misuse Canadians' data. Is the government going to fine itself in such an instance? I doubt it. And that would be a round trip anyways at that point in time. Banks, secondly, have a lot of information about Canadians, and they use that information to increase their returns. They've got large bureaucracies and large legal departments and government relations departments to handle these fines, which I should note in this legislation, many exemptions are included. So we're building more bureaucracy. That's just what Canadians have elected us to do, I say very sarcastically. On top of the 30% increase in federal government employees over the past 6 years, we're going to build more bureaucracy. What this bill should be doing is trying to strike a balance between business use of data and the fundamental protection of our privacy. So let's quickly discuss some of the nefarious uses of digital information gathering. Let's go back to the pandemic, when CERB payments were given out to Canadians, and how many criminal organizations misuse that information, government information, to pilfer the pockets of Canadian taxpayers and get undeserved CERB payments into the wrong accounts. This is what happens when government information is pilfered, and this is the main problem with the privacy of Canadians' information at this point in time. So I'm not going to go on too much longer here, Madam Speaker, but my advice to this government, get this bill moving. You're way behind on other jurisdictions on this very important issue. Look at how the absence of privacy protection has affected Canadians, and take a look at where the value of Canadians' information has gone to all the large American tech companies. Listen to that input and the alternatives that are going to be put before you when you put together this bill, and hopefully you amend this bill so it actually addresses the privacy of Canadians in a more complete manner. Listen to that input, listen to those alternatives, and as the Supreme Court of Canada reiterated 34 years ago, Canada needs to recognize privacy as a right. So let's get to work in providing an outcome that actually safeguards Canadians' privacy. Thank you, Madam Speaker.
Questions and comments? The honourable member for Fleetwood Port Kells.
Well, thank you, Madam Speaker. Wanted to relate to the honourable member an experience I had back, I think, in 2014, 2015. I saw something on Facebook that said, hey, it's Stephen Harper's birthday. Wish him a happy birthday. So I did. I mean, what the heck? I'm a liberal. I know he's a conservative. I disagree with what Mr. Harper did, but a birthday's a birthday. Imagine my surprise if, when after that, I saw posts online that put me down as a supporter of Stephen Harper. That did raise some questions amongst, my family and others. And this is an example of something that also needs to be paid attention to. How many times, for instance, have we been asked to fill out this personality test or whatever, not knowing that we're giving all of this information that could be used against us? So I'm wondering if the honourable member could reflect on that.
The honourable member of Calgary Centre.
Well, I thank my colleague for that question. It's a very good question, and I'm glad to see that often we differ on policies in this House, but it's still good to wish others here happy birthday, no matter if you differ with their policy position one way or another. Cordiality, of course, is very common here. What I'd like to hear is that, you know, we're actually, when we're saying happy birthday to somebody, I think it's recognizable when you're getting on that website and filling out a form that people are culling that information. They're using it and they're actually interpreting it as something which you may not necessarily intend. And that is exactly what's happening in the world right now. How this bill addresses that concern is beyond me at this point in time, because you've actively given that information, and that's going to continue to happen. You've probably filled out the form, or you've probably checked off the box that says, I agree to the supply of this information that is 60 pages long about how to actually access that going forward. This is something this bill needs to address. It's something it needs to address in a legitimate and concise fashion so that small businesses, individuals understand what that relationship is and how it transpires. Thank you.
Commentaire, l'honorable député de Drummond.
Questions and comments. The honourable member for Drummond. Thank you, Madam Speaker. I thank my colleague for his speech. I'd like to restate something I asked earlier of another of his colleagues. That is that there's a very fine line between, on the one hand, protecting the privacy and data of online platform users, and then on the other hand, there is the matter of the safety and protection of those who are more vulnerable to violence online. We talked about it yesterday. There were two interesting speakers by Stop Online Violence. So does my colleague agree that we will have to succeed in stopping those who commit cyber violence, and we need to legislate against cyber violence, but at the same time we need to protect the private information of online users? I thank my colleague for his question. Those who are victims of online crime, artificial intelligence crime, those who are most vulnerable are often seniors. We need to protect those who don't know how to protect their information. So we as a society, we need to protect those who need our protection. Because on the one hand, there are service providers, and then on the other hand, there's the value of personal information. So I thank my colleague for his question.
Honourable member for Victoria.
I want to thank the member for his speech, and I was hoping he could just elaborate a little bit more about some of the concerns around the Personal Information and Data Protection Tribunal. You know, it seems like there's no justification for this tribunal. No privacy regime in the world has this tribunal. It introduces unprecedented levels of complexity, potential delays, and uncertainty. And so I'm curious about the member's thoughts on this.
The honourable member for Calgary Centre, a brief answer.
Yeah, thank you, Madam Speaker. And never in all my speeches have the questions been so astute in this, and that's exactly the case. We've got a tribunal now being created with a whole bunch of people, 6 people, 3 of which are going to have to know something about what they're talking about, which is ridiculous, quite frankly. And it is actually, 6 new people when you've already got a privacy commissioner who can already do all this work and actually supposedly accomplish something. In addition, all the details in this are going to be in the regulations. There's nothing we're looking at here in Parliament that deals with the details, which are very important here for us to look at as well. Thank you.
Excellent.
Resuming debate, the honourable member for Nepean.
Thank you, Madam Speaker. Honourable colleagues, I rise today to speak about Bill C-27. I will focus on Artificial Intelligence and Data Act, but before that I would like to briefly talk about the overall Digital Charter Implementation Act. Canadians have never been more reliant on the digital economy. Yet, the current privacy law was last updated over 20 years ago, before iPhones or Facebook even existed. In the new digital economy, enhanced privacy will not only benefit consumers, but will allow companies to innovate compete, and thrive. We are now at a juncture where over the next few years, the rules of the road for digital privacy and AI are being written and entrenched. That is why it is crucial to have clear rules when it comes to this sector. For Canadians to prosper and benefit from the digital economy, they need to have confidence that their data is safe and trust that their privacy is being respected. That's why the government has introduced this legislation that will ensure Canada has critical protections in place. Bill C-27 will ensure that Canadians have first-class privacy and data protection and that companies that break the rules face severe consequences, some of the steepest fines in the world. It will also hold organizations to a higher standard, in particular when it comes to protecting the personal information of minors by giving them and their parents more power over their information, including the ability to have it deleted. With C-27, we are moving beyond traditional privacy protection to ensuring data control for all Canadians. Canadians can be reassured that we will never compromise on trust and safety of their privacy. Over the last decade, artificial intelligence technologies have been expanding rapidly and have benefiting Canadians in varieties of ways. These technologies are evolving rapidly, and with that, there is an increase in risk and harms due to the use of AI systems, whether intentional or unintentional. The Artificial Intelligence and Data Act, AIDA, would establish rules to promote the responsible use of AI and the related governance practices. The framework would ensure the development of AI systems that has to include plans to mitigate bias and harm, and that organizations are accountable for their practices. The AIDA seeks to regulate international and interprovincial trade and commerce in artificial intelligence systems by requiring that certain persons adopt measures to mitigate risk of harm and biased output related to high-impact artificial intelligence systems. The Act provides for public reporting and authorizes the Minister to order the production of records related to artificial intelligence systems. The Act also establishes prohibitions related to the possession or use of illegally obtained personal information for the purpose of designing, developing, using, or making available for use an artificial intelligence system in an intentional or reckless way that causes material harm to individuals. This will ensure that Canadians have strong privacy protections and clear rules of the road for business, as well as guardrails to govern the responsible use of artificial intelligence. This bill will provide Canada with adequacy within the European Union's GDPR framework and international interoperability on privacy. Further, it will enable Canada to remain on the cutting edge of artificial intelligence development. This bill will help us to build a Canada where citizens have confidence that their data is safe and privacy is respected, while unlocking innovation that promotes a strong economy. University of Toronto's Swartz Reisman Institute for Technology and Society studied this bill, and I would like to quote from an article written by policy researcher Maggie Araye. Quote, "As technology continues to advance and permeate almost all aspects of modern life, it has become necessary for regulators to grapple with how best to regulate it. New ways of collecting and processing personal information necessitate new regulations to protect those whose information is being collected, analyzed, and sold, often whenever they visit a new website or sign up to a new app like Facebook or TikTok. advances in artificial intelligence are also top of mind for many regulators, posing unique risks and challenges that must be addressed. The recently tabled Bill C-27 represents Canadian regulators' efforts on both fronts. The Artificial Intelligence and Data Act is the federal government's first attempt to comprehensively regulate artificial intelligence. Canada is not alone in this. AIDA comes in the wake of similar initial attempts at AI regulation by other governments around the world, such as European Union's 2021 AI Act and the United States 2022 Algorithmic Accountability Act. AIDA, like the EU's AI Act, takes a risk-based approach to regulating AI. However, it is worth noting that Canada proposes categorizing AI based on whether it is high impact, while the EU uses the language of high risk. AIDA is also far less prescriptive than the European Union AI Act. The draft act is quite short, with much room left for the enactment of provincial AI laws, as well as further federal regulation. A person becomes a person responsible for an AI system if they design, develop, make available for use, or manage the operation of an AI system in the course of international or interprovincial trade and commerce. The major requirements contained in AIDA for persons responsible for AI systems include ensuring the anonymization of data, conducting assessments to determine whether AI system is high impact, establishing measures to related risk, monitoring and keeping records of risk mitigation, and requirements for organization to publish a plain language description of all high-impact AI systems on a public website. If any time the minister has reasonable grounds to believe that a person may be in contravention of these requirements, the minister may order that person to conduct an audit to the responsible contravention or engage an independent auditor to conduct the audit. The tabling of Bill C-27 represents an exciting step forward for Canada as it attempts to forge a path towards regulating AI that will promote innovation of this advanced technology, while simultaneously offering consumers assurance and protection from the unique risk that new technology poses. There are sections of C-27 that could be improved, including areas where policymakers could benefit from the insights of researchers with domain expertise in the areas such as data privacy, trusted computing, platform governance, and social impacts of new technologies. To ensure that the powerful new technologies that shape our world today benefit everyone, it is essential that our policies are well informed, especially when it comes to how technology systems work, how they interact with our legal infrastructure, and how they impact society. As we approach the implementation of this landmark regulation, it is critical that Canadians are engaged and informed on these topics and ready to make their voices heard. End quote. I will now quote from an article written by law firm McCarthy Tetrault. Quote, Bill C-27, if adopted into law, is set to have a significant impact on businesses by creating new requirements for those who make, use, or work with AI. The bill imposes several new obligations on the AI sector, which are backed by serious penalties of non-compliance. Thank you, Madam Speaker.
Questions and comments? The Honourable Member for South Shore, St. Margaret's.
Thank you, Madam Speaker. I listened intently with the member Nepean's speech, and I noted at the beginning that the member talked about the issue of children, and the minister went on about that in his opening speech. And this bill is 124 pages. You know how many times minors are mentioned? Once. Doesn't define what a minor is and says minors or information is sensitive, and it doesn't define what sensitive is. So perhaps a member of the Liberal government could define for this House what a minor is under this law, or this proposed law, and what is sensitive information as this says in the definition section.
Member for Nepean.
Thank you, Madam Speaker. There are two things here. One is definition of minor. I think there are well-recognized legislation and adopted by various authorities and institutions who a minor is. I think that will be applicable here. On the second definition of sensitiveness and other definitions related to these fast-changing technologies, Madam Speaker, my view is that we should not cast in iron in the legislation the definitions of various things that are involved here, but leave it to the government and the regulators going forward have the flexibility to define the various terms that are used in this legislation. Thank you, Madam Speaker.
Questions and comments? L'honorable député de Terrebonne.
Merci.
The Honourable Member for Terrebonne. Thank you, Madam Speaker. I'd like to thank my colleague. I'd like him to answer this question. Doesn't he think that since Quebec already has its own legislation that works very well to protect personal data, doesn't he think that it should be set out clearly in Bill C-27 that it will not contravene the law that already exists in Quebec? It should be set out clearly and stipulated in the bill.
Speaker, it's right that Quebec has an existing law, and this law does in no way impede the Quebec's ability to promote and act on its own law. In fact, this legislation will enable Quebec and other provinces to move forward with any changes they may need to improve their own laws to protect the privacy of people. Thank you, Madam Speaker.
The Honourable Member for Windsor. Questions and comments? The Honourable Member for Windsor West.
Thank you, Madam Speaker, and thanks to my colleague for his intervention. As he knows, this bill is actually three pieces of legislation stuck together. And I'd like to get his rationale as to why the Liberals chose that path, especially given that the first two pieces of legislation actually had some time in this House. And under the NDP question to the Speaker about this bill, we actually separated it into two different votes because the artificial intelligence part in particular is new and it requires different processes. It's unfortunate, I think, that they couldn't find a proper way to bring this forward, and I'd like his reflection on that because it appears that Conservatives will not even support bringing this to committee, and it appears as well that the Liberals seemed intent on perhaps even sabotaging efforts where there seems to be some consensus.
For Nepean.
Thank you, Madam Speaker. There are a lot of things that overlap all these three pieces of legislation under one. And especially the thing about artificial intelligence, it goes beyond one particular domain. It acts on almost every aspect of a Canadian economy or Canadian society, and it permeates almost everything else it touches. That's the reason why I guess the government has brought in as one single piece of legislation.
And comments? We have time for a brief question. The Honourable Member for Saanich Gulf Islands.
Thank you, Madam Speaker, and honourable colleague from Nepean. Thank you for the speech. It's my first opportunity to get in on the debate on C-27 today, and I have to say my thoughts resonate a great deal with those mentioned by the Honourable Member from Windsor West in terms of pointing out this is three bills in one. To focus on the part that's completely new, artificial intelligence, I find that there's a great deal of tautology when you look at the bill. For instance, it says that we'll know what's a high-impact artificial intelligence if it, quote, meets the criteria for a high-impact system established by regulations. There are a number of other places. We don't have regulations yet. When will we know what this bill means?
A brief answer from the Honourable Member in Nepean.
Thank you, Madam Speaker. I agree with the Honourable Member that there are a lot of things that can be explained much better. I'm sure that will be looked at the committee level. And with respect to artificial intelligence, it's very difficult to define everything in the legislation because that is a moving thing. Artificial intelligence is evolving on a daily basis. So that is the reason why it is best allowed that to be done through regulations. Thank you, Madam Speaker.
Resuming debate, the Honourable Member for Mission Matsky Fraser Canyon.
Thank you, Madam Speaker. We are here today to debate Bill C-27, the Digital Charter Implementation Act. With this bill, the government seeks to bring Canada's consumer privacy protections up to date, create a tribunal to impose penalties on those who violate those protections, and create a new framework on artificial intelligence and data. For my constituents, I think the most important question is, why are consumer privacy rights important? Well, your personal information has become a commodity in the modern world. Businesses and organizations regularly buy, sell, and transfer your personal data, such as your name, your gender, your address, your religion, what you do on the internet, your browsing history, your viewing and purchasing habits, and more. This happens so often that it's almost impossible to know who has access to your sensitive data and what they do with those personal details. Unfortunately, Madam Speaker, this bill fails to adequately protect the privacy of Canadians and often puts the commercial interests ahead of privacy rights. The first part of this bill is the Consumer Privacy Protection Act, and I will note, as many others have during this debate, that it is really 3 bills in one. It is the largest part of this bill and brings in a new regulation on the collection, use, and sale of the private data of Canadians. I will cover 3 issues, as I have found in this act, related to the first part of this bill. The first issue relates to how organizations may collect or use your information without your consent. Subsection 18, paragraph 3 states, an organization may collect or use an individual's personal information without their knowledge or consent if the collection or use is made for the purpose of an activity in which the organization has a legitimate interest that outweighs any potential adverse effect on the individual resulting from the collection or use and of that data. Without defining what a legitimate interest is, this clause risks giving organizations free rein to define legitimate interest in whatever way suits their own commercial interests. The second issue I'll cover relates to how the bill would protect the privacy rights of children. Subsection 2, paragraph 2 states, for the purposes of this act, the personal information of minors is considered to be sensitive information. However, nowhere in this bill are the terms minor or sensitive information defined. This will lead to confusion about how personal information of children should be handled and ultimately lead to, in my opinion, weak protection of that information. There is also no other provision in this legislation that regulates the collection and use of children's personal data. Now, any parent in this House of Commons is very concerned about their child going on Minecraft, their interaction with other people, other gaming sites. This bill doesn't do enough to protect children in the context of online gaming and protecting them. The last issue I will raise on this act relates to when organizations can rely on implied consent to collect and use personal data. Subsection 15, paragraph 5 states, consent must be expressly obtained unless, subject to subsection 6, it is appropriate to rely on an individual's implied consent, taking into account the reasonable expectations of the individual and the sensitivity of the personal information that is to be collected, used, or disclosed. Madam Speaker, this subsection again highlights the use that this bill lacks a clear definition of sensitive information. This means that organizations will have free rein to determine when they can rely on your implied consent, and they will be free to decide what information is or is not deemed sensitive according to their interpretations and not the legislation's. The second part of the bill relates to personal information and data protection and the creation of a new tribunal act. Second part of the bill, would create a new semi-judicial body with the power to levy financial penalties against those who would violate the CPPA, or the first part of the act. I question whether this tribunal will be able to enforce the penalties outlined in Section 128, which are tied to global revenue and a proportion of profit in a previous fiscal year. How does the government plan on ensuring accurate figures? How does the government really believe that they're going to go after Google in the global context and hold Google accountable and collect possibly up to 4 to 5% of Google's global revenue? It's farcical. We need very clear and very big amendments to this section, and we need to even question whether we need a tribunal, because if it's in charge of enforcing Section 128 of the bill, I know it's already going to fail. Under the third section of the bill, the Artificial Intelligence and Data Act, new provisions are created that apply to the private sector. However, this bill does nothing to address the relationship between government and artificial intelligence. Right now in Parliament, we're debating Bill C-11, which talks about the government's use of algorithms in the context of CRTC. This bill has rightly infuriated Canadians across this country who are concerned about how the government will determine what you say and do on the internet and where you will be directed. Why isn't the government trying to apply the same standards upon itself as it's trying to apply on private corporations? Now, I want to address some other key oversights in this bill. In the UK, EU, and even Quebec, certain personal details such as race, sexuality, and religion are given special protection in comparison with other personal information. Why does this government believe the most identifiable aspects of our personal information are not worthy of being defined as sensitive information in the context of privacy law? Secondly, the bill does nothing to regulate the sale of personal data. I'm just reiterating this point. In a world where the sale of personal data has become an integral part of our economy, why isn't this government concerned with setting clear rules on how and what kind of data can be bought and sold, especially in the context of children? Third point, the bill fails to regulate the use of facial recognition technology. The RCMP used Clearview's AI facial recognition database, which was illegally created. Why does this government not think it is appropriate to ensure this never happens again? Fourth, the Consumer Privacy and Protection Act and the Personal Information and Data Protection Tribunal Act proposed in this bill are nearly identical to the aspects proposed under last Parliament's Bill C-11. The consequence, Canada's consumer privacy laws will be out of date by the time they even come into force. So this bill, Madam Speaker, was an opportunity to put forward strong regulations on the collection and use of personal data, but failed to meet some basic criteria and thresholds. While the increased penalties for violating the Act are welcome, they are watered down by the implementation of a tribunal that will take months, potentially even years, to make a decision and levy fines, and it's even questionable whether such a tribunal could actually do what it's purported to be responsible for. Do we really need privacy legislation that fails to protect the privacy of Canadians? Do we really want privacy legislation that fails to put consumer interests ahead of corporate interests? Do we really want privacy legislation that fails to protect the personal information of children? And do we really want AI regulations that don't apply to government? Frankly, Madam Speaker, this government needs to withdraw Bill C-27, break it up into different parts, and come back to Parliament after they've looked at the drawing board again and done something a little more comprehensive. Thank you, Madam Speaker.
Questions and comments? The Honourable Parliamentary Secretary, the Government House Leader.
Yes, thank you, Madam Speaker. And, you know, it's interesting that the deeper we get into the debate, the deeper the Conservative Party gets into disliking the legislation. And for me, I look at the legislation as something that is going to have a very strong positive impact in protecting the privacy of Canadians. It has penalties that are going to be put in, substantial financial penalties, even though the member opposite mocks those penalties, Madam Speaker. There's issues such as the privacy management programs that businesses are going to have to put forward. There's so much good stuff in this legislation, and yet the Conservative Party is prepared to say, we don't care. We have other things that we have on our agenda. We are going to prevent this legislation from passing. Madam Speaker, my question is, does the member not feel that Canadians deserve this kind of legislation at least as a starting point, and the Conservatives can do whatever they would like afterwards?
Honourable Member for Mission Matsky Fraser Canyon.
Well, thank you, Madam Speaker. Why bring forward legislation that doesn't define sensitive information in the context of children? We all know this is a problem. I acknowledge this is a problem. Why not do the work right now? There's a lot of very talented public servants that can define sensitive information in the context of children. Related to Section 128 and the fines imposed for people that would break the Privacy Act, the ability of the Government of Canada to go after global tech companies and asking them to pay the Government of Canada a portion of their earnings from a previous fiscal year, Like, the government of Canada is just not capable of doing that right now. So it's fluff. It's absolute fluff, Madam Speaker.
Questions and comments? L'honorable député de Beauport-Limoilou.
The honourable member for Beauport-Limoilou. Thank you, Madam Speaker. I was curious to know what my colleague thought about the apps that involve games or quizzes and so on, but are really looking for personal information and contact information, cell phone numbers, and so on. Does he think the bill should also legislate around that? The honourable member for Mission Matsqui.
Un point très important.
That's a very important point. For a parent like me with a 7-year-old son, he's just starting to play games on his iPhone or something like that. So this is not a situation that's covered by this bill. So we can't say that this bill is going to protect children because the definition of sensitive data, there is no definition in this bill, and we need one. Thank you, Madam Speaker.
Questions and comments? The honourable member for Windsor West.
Thank you, Madam Speaker. I think what's unfortunate with the Conservative position here, they've raised some significant problems with the bill, although stopping it for going to committee is rather ironic because the suggestion is to hand this entire project back to the Liberals and their central party organization and their political infrastructure and to start over as opposed to moving this to public debate, witnesses' testimony, and expert dialogue that's necessary. And I'm not willing to turn this entire project back to the Liberal machine. And I think that's what's unfortunate here. And I can attest to the member that his members in the committee are actually very good members. So I'm looking forward, and we've heard speeches from Conservatives saying that they want amendments. Why won't they actually bring it to committee then and get it to amendments? I think that's a better choice than turning it back to the Liberals to whenever that's going to take place.
The honourable member for Mission Matsqui Fraser Canyon has 1 minute to respond.
Well, thank you, Madam Speaker. And I will note that the member from Windsor West, I'm on industry committee with him, and he provides a lot of intelligent insight and corporate knowledge to key pieces of legislation just like this one. Unfortunately, we're in a situation today where the New Democratic Party has decided to support the Government of Canada on all key pieces of legislation. So even if the member from Windsor West has a problem with a key aspect of the bill, I am not confident that the supply agreement between those two parties will result in good legislation. And that is why the Conservatives are calling on the Government of Canada to go back to the drawing board, because at the end of the day, the New Democrats don't have enough money to fund a federal election, and that's why they're supporting the Liberals despite this poor legislation. Thank you, Madam Speaker.
Resuming debate, the honourable member for Hamilton Mountain.
Thank you, Speaker. I am so pleased to rise today to speak about the Digital Charter Implementation Act 2022. With Bill C-27, our government is showing leadership in a new digital world. Privacy is important to the residents of my riding of Hamilton Mountain. It's important to all Canadians. And this legislation will not only benefit consumers, it will allow companies to innovate, compete, and thrive. The world I grew up in is significantly different from the world that my son is growing up in, and this bill gives me confidence that we will be able to take advantage of the latest technologies while at the same time be assured that our personal information is safe and secure. And I want to specifically talk about the Consumer Privacy Protection Act and how it sets out a balanced approach to compliance and enforcement. Canadians clearly want their personal information to be handled responsibly, and they want meaningful consequences for organizations that break rules to gain some advantage. Canadians want fair punishment for truly bad actors. According to a survey published by the Office of the Privacy Commissioner, 71% of Canadians have refused to provide their personal information to an organization because of privacy concerns. And an earlier survey, the same percentage of Canadians, 71%, said their willingness to share their personal information would increase if they knew that the organization would face financial consequences should their information be mishandled. And such consequences are clearly an important tool for enhancing privacy protection for Canadians and also for helping organizations comply with the law right from the start. The Consumer Privacy Protection Act, or CPPA, will assist companies to get privacy right, as the escalating enforcement approach will correct problems as they arise. Speaker, the new privacy law incentivizes organizations to step up and improve their privacy practices at the outset. The CPPA will also provide the Privacy Commissioner with a key role in helping them do so. Under the CPPA, businesses will be able to ask the Privacy Commissioner to review the policies and practices that make up their privacy management program, which will assist them in complying with the law. The Commissioner can also ask to review such programs. And this is a very important step in the early detection and serves to correct problems at the outset. Privacy management programs cover a wide range of privacy considerations: how companies manage service providers, how they respond to breaches, when to undertake privacy risk assessments, employee training, complaint handling, and so on. Under the CPPA, the Privacy Commissioner will be able to examine these policies and practices outside of an investigation. The goal is for the Commissioner to give advice and make recommendations. The CPPA would prevent the Commissioner from using what he or she learns in these reviews with any enforcement action unless the organization willfully disregards recommendations. We think this would be very rare, but if it happens, action can be taken. The approach provides an appropriate space in which the Commissioner can provide advice and companies can take proper action. At the same time, the Commissioner will be able to gain insights on how the law is implemented in real-world situations, thereby being able to better advise organizations on the challenges they may face in the privacy space. Essentially, this approach builds on the Office of the Privacy Commissioner's current business advisory function, which has proven successful in encouraging compliance through engagement rather than enforcement. And by allowing for the review of privacy management programs, the CPPA provides businesses with a safe space to seek and obtain advice and implement compliance solutions at the onset. We believe this will help prevent privacy issues before they have an impact on individuals. Speaker, we know Canadian companies will be very interested in this part of the new law, particularly smaller companies and startups. I could probably think of a few in Hamilton Mountain. The CPPA recognizes that a one-size-fits-all approach doesn't work for privacy. Some organizations deal with minimal amounts of personal information, and for others, it's central to their business model. And that's why the CPPA allows organizations to develop their privacy management programs according to the volume and sensitivity of the personal information that they handle, and why the Commissioner must also take this and a company's revenues into consideration during the exercise of the role under the law. Another important protection under the new Act is the ability of the Privacy Commissioner to review the risk assessments and mitigation measures that organizations must do if they rely on a brand new exception to consent for activities in which they have legitimate interest. Speaker, under the CPPA, the Privacy Commissioner will continue to undertake research and publish guidance. It's a long-standing rule and important in helping organizations meet their compliance obligations. It's a role that we wholeheartedly support. The bill ensures that organizations build privacy considerations into their products and services from the beginning. Working with organizations, giving guidance, this is a fundamental role of the Privacy Commissioner. We want to be proactive here. We want to prevent problems before they have a harmful impact on individuals. But there will be organizations that don't have the right practices. There will be others that have the right practices but still make mistakes. This law provides individuals with the right to complain about an organization's privacy policies when they appear to be offside with the law. And the right to complain is considered to be a fundamental principle in all privacy statutes. Under the CPPA, like PIPEDA, the Privacy Commissioner also retains the ability to initiate a complaint investigation when there are reasonable grounds to do so. This is an important role because filing a formal complaint isn't always obvious. Maybe some people won't know there's a problem, maybe they don't have time to make a complaint. And this is where the Privacy Commissioner should be able to take action when intelligence gathering from media reports and their own research indicates there could be potential trouble. CPPA encourages the early resolution of problems and provides for dispute resolution. Over the years, through its active early resolution approach, the Office of the Privacy Commissioner has successfully been able to resolve many complaints with limited formality. The CPPA maintains such tools for the Commissioner. For example, compliance agreements, introduced relatively recently under PIPEDA, remain in the CPPA. Pursuing these agreements allows companies to work out an acceptable resolution with the Commissioner without the Commissioner resorting to more formal measures like orders. But resolution won't always be possible or desirable. Sometimes the Commissioner will need or want to consider stronger measures. And under CPPA, the Commissioner will have the power to issue orders to compel an organization to take necessary action to bring the organization into compliance. This is a new power and a key improvement over PIPEDA. Prior to issuing such orders and to ensure fairness, the Privacy Commissioner's office will need to go through a new process called an inquiry. And once the inquiry is completed, the Commissioner will issue findings and a decision and will make orders as necessary to an organization to change its privacy practices. And as part of this process, the Privacy Commissioner may also recommend administrative monetary penalties to a new tribunal for certain contraventions of the law. The possibility of significant fines for non-compliant organizations, fines up to 5% of global revenue or $25 million, whichever is greater, for the most serious offenses is another key improvement over PIPEDA. A key part of the new enforcement regime, the Personal Information and Data Protection Tribunal, is established to hear appeals of the Commissioner's decisions. If required, it will also decide whether to issue a monetary penalty, and if so, the amount. Industry stakeholders say we need impartiality in enforcement decisions, given the different roles of the Privacy Commissioner. This was particularly the case for any proposals involving monetary penalties, which have the potential to significantly affect an organization. The new privacy law would support additional due diligence in decisions to impose monetary penalties by introducing an inquiry phase before issuing orders, and by separating the imposition of penalties from the Commissioner's other responsibilities. We know some organizations will challenge the Commissioner's orders and recommendations, and we don't want to burden the courts. This is another reason for introducing a new tribunal. It's intended to be more accessible than the courts. It will ease access to justice for the individual and the organization. After the previous version of the bill was tabled, stakeholders told us it needed more privacy expertise. And we listened, and this version of the CPPA has the necessary privacy expertise to ensure credibility. And I'll wrap up here, Speaker. I see that you're showing me the time. I thank you for your attention.
And comments, questions et commentaires. The honourable member for St. Margaret's, South Shore St. Margaret's.
Thank you, Madam Speaker. And I thank the member for her speech, and I know, and I appreciate that the member has been participating in the debate today. So one of the questions I have is if this is really about protecting the personal privacy of individuals, why does this bill have so many exemptions for businesses? It allows in 18.3 for legitimate interests of businesses to override the interest of an individual, and in 15.5 it allows businesses to use implied consent, not real consent, but implied consent to override the interest of personal privacy. So why is it that personal privacy is not part of the purpose of the bill as a fundamental right?
The honourable member for Hamilton Mountain.
I thank the member opposite for his questions. What I would say is that I think that this legislation needs to be flexible because, as I mentioned in my speech, it applies not only to big corporations, but to smaller companies and to companies that use a lot of personal data and also companies that use very little personal data. So it has to be flexible. It has to be able to work in different situations. It has to be able to work in the future because, as we've seen, technology advances advances very quickly, and we need legislation to be able to adapt regardless of the changes in technology that are happening before we can change the laws to accommodate.
Questions et commentaires, l'honorable député de Drummond.
The honourable member for Drummond. I'd like to thank my colleague opposite for her speech. I think she'll find some sensitivity to my question. I'm very sensitive to the issue of personal privacy, having been myself a victim of a piracy with a credit card purchase made recently. I apparently bought a beautiful quilt, but I never got it myself. So when it comes to protecting victims of cyber violence, we will be studying a bill soon on online hate, and we're looking for a way to identify the culprits, those who hide behind anonymity. So does she think that with C-27, that this might actually create obstacles to adequately legislating the bill on online hate? The honourable member for Hamilton Mountain.
Merci beaucoup.
Thanks very much, Madam Speaker. I'd like to thank my colleague from Drummond for his question. I would say, no, I don't think this bill will create any problems for the other bill that our committee will be studying. We need a lot of different ways of attacking the problems of today's digital world.
River, Northern Rockies.
Thank you, Madam Speaker. And I just have a question for the member. She brought up Google before, but I'll quote Jim Balsillie again, and maybe just I want your response to that. Canada's federal government has repeatedly failed to take privacy seriously and construct a legal and regulatory framework that protects the rights of Canadians in the digital age. How do you respond to that?
I'm going to let him know how I'm going to respond to it, but I'll ask the member to respond to it. The honourable member for Hamilton Mountain.
Thank you, Madam Speaker. I've forgotten the question already.
I'll allow the honourable member to bring it back up because I think I threw everybody off.
So my question was the member across the way talked about Google, and we've always known that there's a close relationship between them and this Prime Minister and the Liberals. But a question from Jim Balsillie. Canada's federal government has repeatedly failed to take privacy seriously and construct a legal and regulatory framework that protects the rights of Canadians in the digital age. Would the member please respond to that?
Honourable member for Hamilton Mountain.
Thank you, Madam Speaker. I think that this government takes privacy very seriously, and that's why we've been working on this legislation since the last government, and that's why we've improved this legislation, bringing it before the government the second time to include things like artificial intelligence and improve security for the privacy of young people on the internet.
Resuming debate, the honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. It's a pleasure for me to be able to speak to Bill C-27 in the House today, a bill that deals with issues related to privacy, as well as the way that this government interacts with large corporations to protect or not the privacy of Canadians. And I want to say at the outset that I'm deeply concerned by the fact that this government has clearly been captured by certain corporate interests. And it's important to distinguish in this discussion between corporate interests and the idea of a free market. Now, as conservatives, we believe very much in the importance and value of a free market and a competitive market, a market that is legitimately a challenging and competitive place for businesses who have to compete with each other to have the best products, where some businesses come in and challenge and steal market share away from other businesses and so forth, where there aren't gatekeepers preventing new entrants coming into business. So we celebrate free markets and the competitive aspect of free markets, rather than a situation in which a small group of large corporations are able to dominate and exercise undue and inappropriate power. So in this House, we have, I think, different parties that have different dispositions when it comes to corporations. You have the NDP that generally takes kind of an anti-business approach in general. You have our party that champions the free competitive market, and you have a government that is sadly captured by specific corporate interests, often at the expense of the free market as well as at the expense of individual well-being. And paradoxically, the NDP, while they criticize the government for that, is fundamentally complicit with the government in, on the one hand, criticizing their agenda as it relates to defending corporate interests, but on the other hand, supporting the government and providing them with the supply they need to continue in their misguided approach. So what we see in terms of this government's relationship with large corporate interests at the expense of the free market often and at the expense of individual well-being is clear across a broad range of cases. We could talk, for instance, about this government's fondness for specific companies in terms of outsourcing and procurement, how they've repeatedly gone back to McKinsey to do work that in fact could have and should have been done within the public service, despite McKinsey's track record on so many different areas. We can talk about the fact that while the public service has grown, outsourcing under this government has expanded dramatically. We can talk about how they have pushed companies to implement forms of political discrimination, such as freezing people's bank accounts. And we could talk about a number of the violations of individual privacy and liberty that happen through this government's close relationship with corporations. And I'll say in general, there's this emerging concept of woke capitalism or stakeholder capitalism that I think we need to be thoughtfully critical of. This idea that large corporations should be making definitive determinations and forcing those implementations on the country using their power, and that governments can push corporations to push woke ideas or in any event, particular views of the common good that arise not through free democratic deliberation, but that come about because of pressure from corporate interests. And we see the government's fondness for this kind of woke corporatism approach, where they try to pressure companies to align with and push their views on various issues. Again, Conservatives are very supportive of competitive marketplaces where businesses are doing business, not assuming a preferential position in social values debates, and where businesses have to compete to survive, and where new businesses are able to compete with old businesses, and where we in fact support in particular the development of new small businesses so that we don't have a concentration of corporate power, but rather we have a well-functioning, effective market economy. That's the vision that Conservatives are defending. So let's talk specifically about the issue of privacy and how we see the working out of this government's kind of approach to and relationship with big corporations in terms of their approach to privacy. Now, I'm very pleased that the Conservative Party uses and has a member-driven policy document. So on issues like this, if you'd like to know, Madam Speaker, where Conservatives stand, it's not just a matter of Conservative caucus discussion, but it's also a matter of drawing from the work that hundreds of thousands of Conservative Party members do, deliberating at the riding level, having discussions, proposing ideas, and bringing those to a convention that then leads to a standing policy document that helps to define and frame the values that Conservatives stand for. And I know our Conservative Party is deeply committed to the idea of grassroots democracy and the role that our members play in all aspects of decision-making. That's very important. And in this particular context, we see that playing out in the area of the policy declaration. And our policy declaration recognizes the fundamental right that people have to privacy. As a Conservative caucus, we are supportive in advancing and bringing to the House that view about fundamental rights, a fundamental right to data privacy that's come to us through the involvement of our members, but I think also that reflects the widely held perspectives of Canadians beyond our membership. A fundamental right around the protection of data. Now, this bill, Bill C-27, it could have mirrored the language from the Conservative Party policy declaration. It does not. It does not recognize the fundamental nature of rights around data privacy. It talks about kind of striking a balance between people wanting to have their privacy protected, but also the fact that there are certain corporate interests of corporations that the government is close to that might be negatively affected if we recognize the fundamental right to privacy of Canadians. So it effectively seeks to say there should be some balance between the idea of protecting people's rights and the fact that, okay, there may be certain large corporations whose interests are involved in or would be negatively affected by recognizing the privacy rights of Canadians. Now, in particular, though, although the bill speaks about a balance at a general level, it is so, to borrow a word from a member opposite, is so flexible that it creates space that you could effectively drive a truck through and so many different exceptions and exemptions that it's not really effectively protecting the privacy rights of Canadians. A member opposite in the speech just given said that this is a flexible framework. The bill is flexible. Flexibility isn't always a virtue, Madam Speaker, and I would say, in particular, flexible for whom? Who is doing the flexing? Who is the one that is able to bend the bill back and forth to their own will and their own interests? And I would suggest to you that the flexing here is not being done by the individual who's supposed to own their own data. The flexing is being done by these corporate interests that the government is close to. So even if you believe that this should be a balanced approach, it is not a balanced approach. It is a highly, quote-unquote, flexible approach in which the bending and twisting is done by the particular interest that this government has been and always, I suspect, will be close to until we're able to have a new government in this country that respects fundamental rights, that respects privacy, and that believes in a free, competitive market in which businesses compete instead of where particular corporate friends of the government are protected. I want to draw the attention of members to specific sections in here that identify broad exceptions in the legislation. Section 18.3 allows the organization or business to use a person's information if they have a legitimate reason for doing so. Now that's pretty flexible, Madam Speaker, right? If you want flexible, say we're gonna say you can't use this data in a certain way unless you have a reason to do so. I would submit to you, Madam Speaker, that most people who do things think they have a legitimate reason for them. Others might not think they have a legitimate reason, but to say you can use people's data, there's an exception if there's a legitimate reason why you want to do it. I would say there likely could be no broader conceivable exception than that one. But there are more exceptions, even if that one weren't enough. The legislation, for instance, in section 15.5, refers to implied consent. So apparently, in the case of privacy legislation, consent is not so sacrosanct because companies can interpret an implied consent in this context. So Madam Speaker, there are clear problems with this legislation in terms of the particulars, but I think we can understand, broader than the particulars, the motivation or the value set which is behind this bill, which is that the government is once again trying to defend corporate interests instead of defending privacy and a genuinely competitive free market. Thank you.
Questions and comments? The Honourable Parliamentary Secretary, the Government House Leader.
Yes, so thank you, Madam Speaker. And it's disappointing listening to the Conservative now after Conservative stand and say, well, we don't like this, we don't like this. And then now this member made reference to some sort of a Conservative policy platform that might actually be there. We don't know, really, because we often question the lack of any sort of plan coming from the Conservative Party. What we know know for fact, Madam Speaker, is that we have substantial legislation that does set the framework, that does protect the privacy of Canadians, that does enable penalties and fines to ensure that there's a consequence when a company breaks its trust with Canadians. That we know. And what do the Conservative Party say? We don't care about this type of legislation because we have our own ideas. My question to the member is, will the member and the Conservative Party not acknowledge that it still is okay to allow the legislation to go to committee where the member can continue to rant on the different ideas, maybe even do something positive, suggest an amendment that he feels would actually make the legislation better?
The honourable member for Sherwood Park, Fort Saskatchewan.
Madam Speaker, it is quite a thing to be accused of ranting by the member from Winnipeg North, and I am so sorry to have disappointed him by my speech. I recall in an earlier exchange he referred to me as a mischievous little fellow, and I framed that and I put it on my wall that the member for Winnipeg North thinks I'm a mischievous little fellow. That is truly having arrived. That was the goal I set out to have been thus recognized by that member from the beginning. But he asks what changes I would like to the bill. I suggest that he support changes that reflect what Conservative members have in their wisdom put forward through our policy declaration, which we as a caucus are strongly supporting, which is the idea that there is a right to privacy, a right to digital privacy, and that right comes before the corporate friends of that member and this government.
Questions and comments? The honourable member for Saanich Gulf Islands.
An honourable colleague for Sherwood Park, Fort Saskatchewan. Thanks as ever for an entertaining speech. I'm looking at C27 and wondering what we make of the fact, and I know he commented on this, we've got 3 different bills, they're all put together, and only one is really new, because we've seen the privacy pieces, the repealing of PIPEDA in the former Parliament's Bill C11, and this act relating to artificial intelligence and high impact AI and regulating that is essentially an entirely different scheme of legislation. Would the Conservatives agree that they should be split so we can examine them separately? I think that's already their position. I'd like to hear what the honourable member says to that.
Member for Sherwood Park, Fort Saskatchewan.
Well, thank you, Madam Speaker. Some members will recall way back in 2015, 8 long years ago, in the lead up to that election, the Liberal platform spoke about no more omnibus bills. They were going to end omnibus bills, Madam Speaker, and that went the way of the dodo bird, as did many of their other election commitments. It was such a sunny time in the rhetoric of the Liberal caucus, and we see this government in terms of their management of their legislative calendar, right? So they put forward bills, then they prorogue Parliament, then they put forward bills again, then they call an early election, then they're putting forward bills again. On the other hand, my constituents are certainly hoping for an opportunity to weigh in on this government at some point soon. But I think the member's point is quite correct that we've seen immense hypocrisy from this government around omnibus bills, and I wonder if we're getting to a point where they'll just try to put all aspects of their legislative agenda all together at once. I think that's probably the direction some of the members want to go.
We have time for a brief question. The honourable member for Prince George, Peace River, Northern Rockies.
Thank you, Madam Speaker, for that. And I guess to respond to the member across the way, he just says, and the Liberal Party and the Prime Minister says, just trust us on this, the member from Alberta. And I guess I would ask the member who just spoke, should we trust this government and this Prime Minister?
The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. My short answer would be no. We shouldn't trust this government. My slightly longer answer would be, look, over the last few years in terms of all of the actions of this government when it comes to people's privacy, and we've seen various actions through COVID and various other actions contemplated, there is a great deal of concern about privacy. There is a great deal of concern about, anytime the government says, don't worry, we're going to protect your information, don't worry, we won't use these systems in this way. Because of the way this government has acted in the past, there is a great deal of concern and distrust. It is this government that has undermined trust in government and institutions because they have not been worthy of that trust.
Hear, hear. Statements by members, déclaration de député. The honourable member for Scarborough North.
Madam Speaker, today members of the Canadian Food Grains Bank are in Ottawa to mark the organization's 40-year mission to end world hunger. Since 1983, they have provided over $1 billion in food-related assistance, working with over 100 international partners in over 70 countries across the globe. A partnership of 15 Canadian churches and church-based organizations, Food Grains responds to emergency food needs arising from conflict, climate change, and other causes of humanitarian crises, while supporting long-term development. Their work is centered around sustainable farming practices, promoting gender equality and enabling communities to enhance their livelihoods and resiliency. Congratulations to Executive Director Andy Harrington, the Board of Directors, staff, volunteers, and member agencies that have contributed to Food Grains' incredible impact over the last 4 decades. May they continue to stay the course and help drive meaningful change. Thank you.
The honourable member for Yorkton Melville.
After over 2 years of uncertainty and lockdown, small businesses are only starting to get back on their feet. A small business in my riding received support through the Canada Emergency Business Account. As an entertainment company that took one of the hardest hits from the lockdown, they originally qualified for the loan and depended on it. SEBA kept their lights on. But now this business owner is shocked by the Liberals' claim that he, along with 50,000 others, were not eligible for the loan in the first place and are required to pay it back immediately and in full. With no recourse to appeal the decision, a simple error made on the application may now result in the complete loss of his business, and he's terrified. The hypocrisy is astounding. While Liberals shake down hardworking business owners for $2 billion over clerical errors, they have no problem shelling out $15 billion to high-priced consultants and friends who are wealthy enough to pay their own bonuses to executives. Once again, this government flaunts its inability to manage Canadians' hard-earned tax dollars while abusing its power, intentionally choosing winners and losers.
The Honourable Member for St. Laurent.
Madam Speaker, tomorrow, March 8th, is International Women's Day, a day to honour women of the past and present, a day to celebrate the achievements of women who came before us and fought so hard to get us to where we are today. And while we've come so far, there is still very much for us to do to help future generations of women to live in a fairer world. Whether we're talking underrepresentation right here in the House of Commons, the mega health research gap between men and women, femicides and gender-based violence, women still face barriers and obstacles that make it impossible to say that we live in an equitable society. Cette année, le thème de la Journée internationale.
This year, the theme of International Women's Day is Embrace Equity. Don't just say it. Think it. Be it. Do it. Value it. Truly embrace it. We can all challenge gender stereotypes, call out discrimination, draw attention to bias, and seek out inclusion in all spheres. Forging gender equity isn't limited to women solely fighting the good fight. Allies are incredibly important for the social, economic, cultural, and political advancement of women. Thank you. The Honourable Member for Thérèse de Blainville. Madam Speaker, the City of Blainville has applied to host the Quebec Winter Games 2026. Mayor Eliza Poulain, who is the first female mayor of Blainville, brought the community together behind this candidacy. She brought on board Mathieu Poirier, the owner of Jardin Dion, a pillar of the community, as chair of the committee. She can also count on a trio of high-level spokespeople, sportscaster Yannick Bouchard, athlete Myriam Boulot, and former goalie Jean-Sébastien Giguère. Therefore, I would like to join my voice with theirs by supporting the candidacy of Blainville. It has everything to host the Quebec Games 2026. Go, Blainville, go.
I just want to remind members who are coming in to please keep the noise down. We're starting to get quite a bit of a hum, and members are doing their statements right now. The honourable member for Etobicoke Lakeshore.
Madam Speaker, it's the month of March, and that can only mean one thing. It's Irish Heritage Month. On March 10th, 2021, this House unanimously adopted Motion 18. As we celebrate the contribution the Irish have made to building our country, I encourage Canadians in every city and town to take a look in their own community to see that Irish fingerprints are everywhere. From contributing to our culture to building the foundations of our educational, religious, and government institutions, the contributions are many. Look no further than the Rideau Canal, or consider that 3 governors general came from Ireland. Stay tuned for Irish Ambassador Eamon McKee's 50 Irish Lives initiatives to learn more. Madam Speaker, over 14% of Canadians claim Irish ancestry, including myself, and I'm very proud of that. The bottom line is this month is for all Canadians, and I want to wish everybody in this House and across our country a very happy Irish Heritage Month.
The Honourable Member for Grand Prairie, Mackenzie.
Deny, duck, delay, distract. That is a track record of this Prime Minister over the last 8 years, every time he gets caught in a cover-up. When the media reported that the Prime Minister knew Beijing was meddling in Canadian elections and he did nothing about it, he denied it. He said that the media was wrong. When even more evidence came to light, the Prime Minister ducked for cover. He left the country to avoid questions. When even more evidence piled up, the Liberals deployed delay tactics, filibustering, stonewalling, now reviews and rapporteurs. The Prime Minister will now try to distract Canadians, claiming that a secret committee conducting secret meetings, hearing secret evidence, writing a secret report that the Prime Minister will edit will finally get to the bottom of it. Enough with the delaying, the denying, the ducking, and the distracting. Canadians deserve to know the truth. It's time for a public inquiry to finally uncover the truth that this Prime Minister is so desperately trying to keep covered up.
The Honourable Member for Brampton South.
Mr. Speaker, it is with a heavy heart that we commemorate the life and legacy of the former Brampton Senator, the Honourable Lorna Millen, a remarkable woman who dedicated her life to serving her community. Lorna was a trailblazer, a leader, and a champion for Brampton. She served as a Liberal senator for over a decade, leading on important causes such as women's rights and environmental protection. She received many awards and recognitions for her contribution to Canada. She was a member of the Order of Canada and was awarded Queen Elizabeth II's Diamond Jubilee Medal for her public service. Her legacy will continue to inspire us. I send my condolences to her husband and a former Liberal member of this House, Ross Millen. Her children, Rob, Jean, and Alec, family, friends, and loved ones. Thank you, Mr. Speaker.
The Honourable Member for Surrey Newton.
Mr. Speaker, throughout February, I participated in several Black History Month events. One such event alongside Parliamentary Secretary to the Prime Minister and colleagues from London West, Fleetwood Port Kells, and Steveston, Richmond East was with local leaders which inspired dialogue and support for Black achievement. I also joined Diversity Community Resources Society's first annual Black in BC event, which celebrated Black excellence. Thanks to leadership of CEO Neelam Sohota and COO Garrison Duke, this empowering event connected Black professionals, leaders, and youth alongside with individual and organizational allies in celebrating the achievements, cultures, and contributions of Black Canadians. Members, please join me in thanking Surrey's Black leaders and organizations for their dedication, passion, and commitment to making our community a stronger community.
The Honourable Member for Simcoe North.
Mr. Speaker, on April 1st, the government is increasing the excise tax on alcohol, beer, spirits, and wine by over 6%. If inflation wasn't hurting Canadians enough, now they have to dig deeper in their pockets to enjoy their favorite libation. It's expected that this will cost taxpayers, Canadians, consumers, and businesses $125 million more next year. It's enough to drive you to drink. The excise tax affects all producers, big and small, including local breweries like Quail's Brewery in Oro-Medonne, and the entrepreneurs who are just starting out now have to manage a higher cost. So why doesn't the government just pause the tax hike, if even just for a year, or cap it as a reasonable level when inflation's out of control? Put a cork in the escalator. Free the beer. Let Canadians enjoy their favorite spirit without having to dig deeper in their pocket. What would Bob and Doug McKenzie have to say, Mr. Speaker? Stop hosing us, eh?
The Honourable Member for Mississauga, Erin Mills.
Mr. Speaker, this week we welcome the Canadian Food Grains Bank to Parliament Hill as they celebrate their 40th anniversary. In a world challenged with inequality, they've played a pivotal role towards ending global food insecurity. This includes funding 106 projects in 34 countries, serving over 900,000 people, providing food assistance to earthquake victims in Turkey and Syria, and supplying relief to Ukrainian refugees. Yesterday, I spoke at a panel to young Canadian Food Grains Bank supporters from across Canada to discuss the value of Canadian aid and critical work that they do. For the past 40 years, our government has been proud to call the Canadian Food Grains Bank a partner and ally. Congratulations to the Canadian Food Grains Bank on their 40-year anniversary as we work together toward a hunger-free world once and for all. Thank you, Mr. Speaker.
The Honourable Member for Kamloops Thompson Caribou.
After 8 long years of this Liberal government's catch and release policy, Canadians feel unsafe. Police are tired of arresting the same people day after day, week after week, month after month. The Justice Minister has an army of lawyers, an army of bureaucrats, and despite those resources, we've seen nothing on bail. But we as Conservatives have listened to the police. We have listened to victims. We listened to Canadians. I put forth Bill C-313 within a matter of weeks. No army of lawyers, no army of bureaucrats, just a Conservative team that is willing to act. Premiers, police, Canadians ask for change. Crickets is what we heard. How many Canadians need to be victimized? How many police officers need to die? It is time for this lethargic Liberal government to get out of the way so we can clean up their mess on bail.
The Honourable Member for Lethbridge.
Well, Canadians, they love watching YouTube, they love listening to music on Apple or Spotify, and they sure enjoy binging on things like Netflix, Disney, and Prime. They love it because they have control over what they watch and when they watch it. And for creators, well, they've never had it better. As long as they have access to the internet, they can start a channel or make a presence online. And as long as they're willing to work hard and put in the creative energy, they can achieve great success, not just in Canada, but around the world. Bill C-11, however, is about to change that. Bill C-11 will give the government the power to censor what Canadians can see and post online. Content creators from across Canada, along with consumer groups, have spoken out about the dangers of this bill. Legal experts have called it a grotesque overreach of government. And when referencing this bill, Margaret Atwood didn't mince her words in calling it creeping totalitarianism. Today, we're calling on the government to kill Bill C-11.
The Honourable Member for Vaughan Woodbridge.
Thank you, Mr. Speaker.
President of the Canada-Europe Parliamentary Association, I would like to formally welcome President of the European Commission, Ursula von der Leyen, on her first official visit to Canada. Welcome.
Canada's relationship with the European Union is the oldest formal relationship the EU has with any industrialized country. We are strategic partners and close friends, bonded by our shared history, common values, close cooperation, and close people-to-people ties.
The EU have wholeheartedly supported Ukraine and will continue to for as long as it takes.
We know Canada-EU relations are key to safety, prosperity, and security. That's why we stand united. This visit aims to strengthen our bilateral ties, further trade, grow our economies, and continue to uphold the rule of law.
Welcome, bienvenue, benvenuta, and benvenutos, European Commissioner President. Thank you.
Bravo. I just want to remind the honourable members that statements are being made, so if they don't mind just listening in, because there's some very interesting stuff being said. The honourable member for Victoria.
Mr. Speaker, generations of Indigenous people have experienced and continue to be impacted by violence at the hands of Canada's colonial systems. Geraldine Gladstein is a constituent in my riding and an Indigenous woman from Panama who's been using her platform as a filmmaker to shine a light on the ongoing genocide in Canada. Geraldine's Our Missing Sisters initiative focuses on the Highway of Tears and aims to honor the lives of those who were murdered and those who've gone missing, but also to engage Canadians broadly in our collective responsibility. For too long, the work of reconciliation and fighting for Indigenous rights has fallen to Indigenous people. We must all take on this work, and it's critical that the government step up and implement all the calls for justice from the National Inquiry into Missing and Murdered Indigenous Women and Girls. As we honor the lives of those we've lost, we must also take immediate action to stop the ongoing violence against Indigenous people. Thank you.
If I can have your attention, please. Order. Order. Very good. We'll continue now. The
Honourable Member from Mirabel. Mr. Speaker, allow me to pay tribute to those who carry on a very Quebec tradition, which is part of our history and identity, that is sugaring off season. Quebec accounts for 72% of global maple syrup production, and everything else is simply fake and should not be tasted. Mr. Speaker, the Quebec maple industry goes hand in hand with research and new technologies and accounts for $500 million in annual exports. Every spring in my riding, nothing can stop these passionate men and women who are very proud of this industry and highly perfectionist. Thanks to them, thousands of us gather in sugar shacks to enjoy food with our families. Mirabel welcomes visitors from all over the world during this season, and it's thanks to Tourisme Mirabel and its Director General, Stéphane Michaud, who does exceptional work to showcase our national treasure. Mr. Speaker, I might be biased, but I would like to declare proudly and solemnly that Mirabel is the world capital of the maple industry. Welcome and happy sugaring.
For Brentford, Brent.
Mr. Speaker, after months of denying the possibility of foreign interference in this country, the Prime Minister finally declares yesterday that there would be an investigation. However, a so-called rapporteur personally selected by the Prime Minister with secret hearings, secret evidence, and secret conclusions all being drawn behind closed doors is not exactly the open and transparent inquiry Conservatives had in mind. That's right. It's no surprise that the Prime Minister is looking to bury the truth from Canadians, as for 5 straight years the Liberals have blatantly ignored recommendations from the National Security and Intelligence Committee of Parliamentarians. As a result, this government has failed to respond to threats posed by foreign states against Canada. Enough is enough. An independent public inquiry must be established in order to openly and honestly understand how to eliminate foreign interference in this country.
The Honourable Member for Toronto Danforth.
Mr. Speaker, Canadians are good at saying sorry, but sorry, not sorry, because we are kicking bleep with our Canadian talent on the world stage. We are highlighting this week Made New campaign. It's celebrating Canadian film and television right around the world as people are popping out the popcorn and the snacks to watch the Oscars this weekend. You're going to have an opportunity to celebrate some amazing Canadian-made films with Canadians in them, including Turning Red by Domichi. I really like that one. Women Talking by Sarah Polley. The Sea Beast by Chris Williams. Fire of Love by Ina Fishman. So much more for you to check out. We have great Canadian talent. We're making a mark on the world stage. Let's keep celebrating Canadian talent.
Bravo. La présidence souhaite.
The chair is ready to rule.
Who wish to participate remotely in committees, be it in committee or elsewhere. On February 15th, 2023,
I just want to make sure everybody hears this and is going to be going along with it and understands how to use their headsets.
On February 15th, 2023, the member for Salaberry-sur-Roi sought guidance from the chair on the technical requirements for remote participation and more precisely on the use of House-approved headsets. The member also inquired about the mechanism to ensure compliance regarding the use of the appropriate equipment. Since the House began holding hybrid proceedings, members have been advised and continuously reminded that the effectiveness of remote participation is based in large part on the use of proper equipment. This ranges from an optimal internet connection, the type of device used, and includes the need for adequate sound quality. Indeed, headsets with an integrated microphone ensure suitable audio quality while respecting the health and safety of interpreters.
And so if they're going to use the headsets, they'll know what I've just said, and there's no reasons or excuses for not being heard or not going through. The chair has previously reminded members of this and the availability of the House administration to provide assistance as required. In a statement from November 26, 2021, the chair stated at page 233 of the debates, and I quote, "Members are responsible for ensuring that their internet connection and audio quality are strong to allow them to participate. A wired connection is more reliable than Wi-Fi, and using computer provided by the House is a better option than using a tablet or cell phone. Using a headset with an integrated microphone will ensure the best sound quality, which is essential for allowing our interpreters to do their work safely. If you have not been provided a headset, please let our IT team know," and I unquote. Proceedings of the House must be available in both official languages. The ability for members to be heard and to hear what other members are saying in the official language of their choice through simultaneous interpretation is vital to our parliamentary system. Thus, technology and the use of the appropriate equipment currently available to everyone plays a fundamental role in ensuring members are heard and understood. I may not dispense, but I would wish that everyone would listen. Le personnel de
While technical staff and interpreters work tirelessly
From the top? Do you want me to start from? Le personnel de soutien technique.
While technical staff and interpreters work tirelessly to resolve issues as they arise, using House-approved equipment is necessary not only to prevent interruptions, but to ensure workplace health and safety. In this regard, the Labour Program of Employment and Social Development Canada has recently issued the following directive to the Translation Bureau, quote, that during meetings with simultaneous interpretation, the interpretation work will be done only when the virtual participants are wearing an ISO-compliant microphone, unquote.
The House has been informed by the Translation Bureau that their interpreters will be operating under this directive going forward. They will not be able to provide simultaneous interpretation if members and also witnesses, in the case of committees, participating remotely are not wearing the appropriate headsets. As an institution, the House continues supporting the ongoing efforts made by the Translation Bureau to ensure the safety of the interpreters.
Consequently, members received an official communiqué by email on February 17, 2023, and a reminder was also sent this morning informing them that the use of House-approved headsets will be mandatory for remote participation in parliamentary proceedings. A list of other compliant devices was also included in the communiqué. And if there is something that I would like to point out, please check the devices that you have, that you used in the past, and compare them and make sure that your current device is on the list. Members will find copies of the communique on each desk in the chamber as well as in the lobbies.
Over the past year, the House has supplied members with new ISO-compliant equipment. While the onus is on members to use the approved headsets when participating in proceedings, the Chair will also provide assistance to ensure all members are in compliance with technical requirements. In cases where the Chair is made aware of compliant equipment is not being used, a member participating remotely will be interrupted and/or not recognized for debate. Issues pertaining to the audio system and simultaneous interpretation should continue to be brought to the attention of the Chair. Considering the whips often know in advance who will be participating in the proceedings, the Chair will also be looking for their support to ensure the appropriate headsets are worn and that everyone is conforming to the new directive. Les ambassadeurs.
The IT ambassadors remain available to help members prepare for their interventions in the House and in committees. Members should not hesitate to reach out to them to confirm their equipment compliance or to perform sound checks. In addition, members participating remotely are encouraged to avail themselves of the opportunity to participate in the sound checks for remote participants in advance of each committee meeting.
Be important. It can make an important impact in ensuring that meetings can unfold with fewer issues and help ensure we can respect our official language's commitments. As always, the health and safety of interpreters, other staff members continues to be a priority for the House of Commons. I want to thank the members for their attention, and if they don't want to hear this long message again, please conform with the directives. Thank you. Oral questions. Question orale, the Honourable Leader of the Opposition.
It's been 10 years since the Beijing authoritarian government has been helping the Prime Minister, beginning with a $200,000 donation to the Trudeau Foundation and meddling in 2 elections to support Liberal candidates. What does the Prime Minister want to do now? He wants to strike a secret committee to investigate secretly and formulate recommendations secretly. And what happens at the committee will stay in the committee. What does the Prime Minister have to hide? The Honourable Minister. Mr. Speaker, on the contrary, we have done much to reassure Canadians about what we're doing to counter foreign meddling in our elections. He talked about 10 years, but 13 years ago it was that CSIS raised the issue of foreign meddling in our elections. My colleague was Minister of Democratic institutions at the time, and he did nothing. That's the opposite of our record in government, and we will continue to do what needs to be done.
13 years. Why have they never done anything about it? 10 years ago, the dictatorship in Beijing gave the Trudeau Foundation $200,000. They then interfered in 2 elections to help keep the Liberals in power. They've even helped campaign for certain Liberal candidates. And what's the solution now? The Prime Minister proposes a secret committee. They will do a secret investigation with secret outcomes. Mr. Speaker, this committee will follow the rule of Fight Club. First rule is no one talks about the committee. Why is the Prime Minister trying so hard to keep everything so secret?
The Honourable Minister.
Mr. Speaker, the Leader of the Opposition knows very well that our government has taken very robust measures to protect democratic institutions from foreign interference. Last night, the Prime Minister announced additional measures that will reassure Canadians not only, Mr. Speaker, that our democratic institutions are protected from foreign interference, but those who seek to interfere with these very institutions will be held to account. And that's something, Mr. Speaker, the previous Conservative government did absolutely nothing about.
The Honourable Leader of the Opposition.
Well, I forgot to mention, other than the secret committee that will see secret information and never actually publish any information, there will also be something called a rapporteur, a fake new position that they have invented. Rapporteur. Does it come with a costume? Maybe a cape or and a sword? Is the best they can come up with a fake position doing fake work? Why is it that they're trying to cover up the truth, Mr. Speaker?
The Honourable Minister for Interparliamentary Affairs.
Mr. Speaker, we didn't need another reason to see that the Leader of the Opposition has never taken this issue seriously. In fact, yesterday, Mr. Speaker, he said something that was shocking. When I pointed out to him that this has existed as a challenge to Canadian democratic institutions, including when he served as Minister of Democratic Reform, he said, of course the previous Conservative government did nothing about it because it wasn't in their partisan advantage to do anything about it. Think about that, Mr. Speaker. Protecting our democracy is not a partisan issue, it's a Canadian issue.
The Honourable Leader of the Opposition.
Why won't the Prime Minister stand up today and answer a question? Why is he hiding? Why won't he stand in his seat? What is he hiding from Canadians that he stands behind this substandard minister? He's been hiding this for 10 years, Mr. Speaker. Whatever it is that he's hiding, it must be bad. It must be really bad. How bad is it?
The Honourable Government House Leader.
Mr. Speaker, it is the height of irresponsibility when talking about national security to talk about the fact that national security should just be set aside, that we should just to open up this as if it could be done. Mr. Speaker, it is not something that I think is being responsible. Responsible leadership is saying that every member of this House, every single member of this House is totally and utterly committed to protecting Canadian democracy. The assertion that anything else is true is offensive, untrue, and playing games with national security is not appropriate.
The Honourable Leader of the Opposition.
Well, if the Prime Minister really was interested in protecting national security, he wouldn't be hiding. He'd stand up right now and answer the question. Instead, he hides behind these two stooges who protect him.
Order! On both sides, order. I want to remind the honourable members two things. One, please use parliamentary language and be judicious. And two, we can't do indirectly what we can't do directly in the House. The Honourable Leader of the Opposition from the top, I'm sure he'll use both principles in his questions. Thank you.
Prime Minister was hiding yesterday from the House. He's hiding today in the House. He's hid for the last 10 years.
Once again, I want to remind the honourable members that we can't do indirectly what we can't do directly. Now, I don't want to have to move to the next question. I'm sure the honourable member from the beginning, and he will use parliamentary judgment. The Honourable Leader of the Opposition.
Mr. Speaker, Prime Minister has been hiding this for the last 10 years. 10 years ago, he found out that the Trudeau Foundation got $200,000. Over the last 5 years, he's had briefing after briefing warning of interference by Beijing in our elections to support him. And now he's hiding the truth behind a secret committee that will not provide public information. Whatever he's hiding, it must be bad. It must be really bad. How bad?
The Honourable Government House Leader.
Mr. Speaker, the member across, the Leader of the Official Opposition, would know well where the Prime Minister is today. He's meeting with the President of the European Commission to talk about national security issues.
I just want to remind the order. Order.
Resign.
Order. Again, I want to remind the honourable members that there's one thing that they cannot do is refer to either the presence or the absence of someone in the chamber. I will let the honourable government House Leader start from the top, please, and I'm sure he'll be judicious in his words.
Thank you very much, Mr. Speaker. And of course, that question was asked despite you saying that it was unparliamentary several times. I want to put as a matter of record. But let me say this, Mr. Speaker, and be very clear. Well, one of the things that we had as a long tradition in this country was to make sure that when we were dealing with national security, that we did not use national security as a way to play partisan politics and to grind on axe on one another. Mr. Speaker, the reality is that this issue of foreign interference has been a serious issue since well before this government. It was a matter that was that the member across was responsible for as a minister. They did not take action. We have
Honorable député de la Prairie.
The honourable member for La Prairie. Mr. Speaker, yesterday at a press conference on Chinese meddling, the Prime Minister showed that once again he hasn't understood a thing. We wanted a public inquiry. Public. He gives the job to a committee that's bound by secrecy. That's not public. That's secret. We wanted an independent investigation. Independent. The Prime Minister appoints a special rapporteur, chosen by him, answerable to him, who reports to him. There's nothing independent about that. Why does the Prime Minister refuse to set up an independent public commission of inquiry? The Honourable Minister.
Monsieur le Président.
Mr. Speaker, the Prime Minister was crystal clear yesterday. Since we took office, we took strong steps to counter foreign meddling in our elections. We also are going to appoint a special rapporteur to investigate all of these issues transparently and make recommendations to the government as to the next steps that we will continue to take to reassure Canadians that our elections are free and democratic and that everyone in this place was legitimately elected by Canadians. The Honourable Member for La Prairie. Mr. Speaker, what the Liberals don't get is that this is not about the opposition versus the government. It's not about one party against another. It's about public confidence in our elections. What we need to know is if the deck is already stacked. If we can't assess the integrity of our elections in a transparent way, honestly, we're in big trouble. We're straying into banana republic territory here, with all due respect for bananas. What's it going to take for them to set up a public and independent commission of inquiry? The Honourable Minister. Mr. Speaker, we share precisely the same concern that my colleague opposite expressed in terms of reassuring Canadians, as we've done since taking office, to reassure Canadians that our intelligence services are effectively collecting intelligence and that we are protecting our system. Since we took office, we've taken further steps, and that's precisely what the Prime Minister announced last night as well. The Honourable Member for Burnaby South. The allegations of foreign meddling are serious and disturbing, and that's why we called for a public inquiry at committee. We want a public and independent process. Why is the Prime Minister not respecting those two criteria? The Honourable Minister.
Monsieur le Président.
Mr. Speaker, I obviously appreciate the question from the Leader of the NDP. We share the concern that all people here should share about the importance of strengthening our democratic institutions. That's precisely what we've done since taking office. Yesterday, the Prime Minister announced further steps, extra steps, to add to those protections. We understand the need to do this transparently and openly, and that is exactly what we will keep doing.
Député de Burnaby Sud.
If the Prime Minister really wanted to restore the confidence of Canadians, he would call a public inquiry. Here's the situation. We've got a Conservative Party that only cares about playing political games with something as so serious as our democracy. New Democrats understand that this is serious and it's not an opportunity to play political games. That's why we demanded a public inquiry in committee. There's two criteria that we have. The process has to be independent and it has to be public. Now, will the government confirm that their process will answer questions about what the Prime Minister knew, when he knew it, and what he did about it?
The Honourable Minister for Public Safety.
Mr. Speaker, my honourable colleague values transparency. So does this government. That is why yesterday, when we announced the imminent appointment of a special rapporteur, we said that we would abide by and respect any recommendation that that individual would put forward, including up to a public inquiry. Equally, Mr. Speaker, I would remind all members of this chamber that we also announced we would commence consultations on a foreign agent registry, as well as the launch of a coordinator to fight against foreign interference. Mr. Speaker, I sincerely hope that is something that all members in this chamber are united on. Thank you.
The Honourable Member for Thornhill.
The Liberals and the NDP are now openly working together to cover up the truth. And yesterday, the Prime Minister kicked the can down the road by announcing that a hand-picked rapporteur is going to maybe looking into the interference. He announced that a secret committee with secret hearings will hear secret evidence and then give the Prime Minister a secret conclusion. When will he call a public inquiry and tell everybody what he's hiding?
The Honourable Minister.
Mr. Speaker, you heard the government announce yesterday that it is our intention to appoint a special rapporteur who presents the qualifications and the experience and the knowledge to navigate and survey the options on the best next practical steps that we can take to protect our democratic institutions, including our elections. And is this truly what the Conservatives have resorted to now, denigrating the very institutions that are there to protect our democracy? Is that all they have to offer, denigration? I sincerely hope not.
The Honourable Member for Thornhill.
That was desperate. It's a special rapporteur. I get it. The Liberals are blocking a public inquiry. The NDP is blocking a parliamentary inquiry. And as a result, Canadians get a secret committee to look into interference by a foreign dictatorship in our democracy. It's shameful work by the cover-up coalition. Will they commit to a truly independent and actually public inquiry to look into what the Prime Minister is hiding?
The Honourable Minister for Parliamentary Affairs.
Mr. Speaker, our honourable colleague keeps referring to some secret committee. I think that would be very disparaging for the women and men who serve on the National Security and Intelligence Committee of Parliamentarians, Mr. Speaker. We set up in legislation an oversight mechanism to look at these very issues, something the previous Conservative government refused to do. Members of her party serve on that committee, Mr. Speaker. Members of all political parties represented in this House and senators, they've done good work and we'll continue to work with them on these important issues.
The Honourable Member for Wellington, Halton Hills.
Mr. Speaker, Beijing's foreign interference is a serious threat, a national threat. It threatens the integrity of democratic institutions, social cohesion, the economy, long-term prosperity, and fundamental rights and freedoms. But this government hasn't treated the threat seriously. It's hid behind all sorts of excuses and accusations like anti-Asian racism. Now it's hiding behind a secret committee with secret hearings, secret evidence, and secret conclusions, all controlled by the Prime Minister. When is this government going to come clean with us and with Canadians about what exactly is going on?
The Honourable Minister for Public Safety.
Speaker, my colleague knows well that this government takes the work of fighting against foreign interference very seriously. That is why we introduced Bill C-59, which would give CSIS the threat reduction measure powers that they needed to address and mitigate that risk. That's why we introduced Bill C-76 to crack down on foreign funding, which could interfere with our elections, but with the corresponding transparency to create the NCCOP, the NCIRA, all of which ensures that we can be upfront with Canadians so that we can defend our democratic institutions institutions. Mr. Speaker, the Conservatives should rise above the fray and see that this is not a partisan issue.
The honourable member for Wellington Halton Hills.
Mr. Governor, if the government treated this threat seriously, it would listen to the advice of CSIS. CSIS has said that an effective way to counter foreign interference is through sunlight and transparency, to build resilience by informing Canadians about interference threat activities. This government's done the opposite. First, it hid behind excuses and accusations. Then it hid behind a secret committee and behind a special rapporteur. This government has been anything but transparent about this. It's burying the truth in process. Why?
The Honourable Minister for Intergovernmental Affairs. The Honourable Minister.
Mr. Speaker, my honourable friend likes to refer to what CSIS said. Let's talk about what they said in 2013, when the Leader of the Opposition was Minister responsible for democratic institutions. They specifically warned 10 years ago, when diaspora groups in Canada are subject to clandestine and deceptive manipulation by a foreign power in order for it to garner support for its policies and values, these activities constitute a threat to the security of Canada. What did the then Conservative government do for 2 years after that 2013 threat, Mr. Speaker? Absolutely nothing.
The honourable member for Mégantic-L'Érable. Mr. Speaker, the cover-up continues as more and more facts are revealed in the media about the Prime Minister's inaction on the Beijing Communist regime's meddling in the elections. The Prime Minister wants to keep up the cover-up. Yesterday, he announced that a secret committee with secret hearings, secret evidence, and secret findings was his big solution to this serious problem. This morning, Liberal members on the Procedures Committee added another layer, blocking the three opposition parties' motion to call Katie Telford. Will they have the courage to let the Prime Minister's senior advisor reveal her secrets, yes or no? The Honourable Minister. Mr. Speaker, my honourable colleague knows full well that we've been very transparent with the Procedure and House Affairs Committee. A number of ministers have appeared over the months. We've been available as we should have been. All the officials responsible for security and intelligence services in Canada have been available. And I will have the great privilege myself of attending with the Foreign Affairs Minister perhaps in a couple of days to answer questions from our colleagues as we should and as we have always done. The Honourable Member for Mégantic-L'Érable. Mr. Speaker, why not bring along the Prime Minister's special advisor then? A special committee with secret hearings, secret evidence, secret witnesses chosen by PMO with secret findings. And who gets to choose which findings to make public? You'll never guess. The Prime Minister's office. And that is why we need Katie Telford to testify. What she says goes to the Prime Minister. Why doesn't she come and tell us what she said at committee? The Honourable Minister.
Monsieur le Président.
Mr. Speaker, my colleague is whipping up a lot of indignation here, as is to be expected, but we have always been transparent with all parliamentary committees. That is the responsibility of ministers. We are accountable to our parliamentary colleagues at committee. That's exactly what we've done. And we've also made available all the senior officials from the security and intelligence services, deputy ministers and so on, to answer questions. And they'd be happy to appear again at the committee's request. The Honourable Member for Trois-Rivières. Mr. Speaker, foreign meddling in our elections requires a transparent investigation. Here's the Prime Minister's idea of transparency. He's putting the investigation in the hands of the National Security Committee, whose members aren't just bound to secrecy, they're bound to perpetual secrecy. A committee that meets behind closed doors where neither the public nor parliamentarians can watch the proceedings. A committee that can't say who the witnesses are or exactly what they said. A committee whose report will inevitably be redacted. Where's the transparency in all that? The Honourable Minister of Public Safety.
Monsieur le Président.
Mr. Speaker, our government has increased the level of transparency with the creation of NACI-COP and INSERA. And yesterday we announced that we're going to appoint a special rapporteur to navigate and assess all the options and make recommendations. And the government will respect that choice and the recommendations of the special rapporteur. That is how we are respecting the value of transparency. The honourable member for Trois-Rivières. Thank you, Mr. Speaker. I'm still shivering from that answer. Mr. Speaker, we need a transparent and independent investigation, but the Prime Minister is creating a so-called independent special rapporteur, but he gets to choose who. Then that person chosen by the Prime Minister decides what to investigate, but also what not to investigate. The Prime Minister's selected special rapporteur will decide whether the Prime Minister should do more to combat foreign meddling. Mr. Speaker, this special rapporteur may well be special, but who can trust that he or she will be independent? The Honourable Minister. Mr. Speaker, the government is going to choose a special rapporteur who has all the qualifications and expertise that's needed to navigate all the options and make recommendations based on the best possible advice that can be given to the government. That is how we are going to respect the value of transparency, to protect our democratic institutions and to protect our elections. The Honourable Member for Trois-Rivières. Mr. Speaker, I'm getting even more goosebumps. Mr. Speaker, foreign meddling in our elections requires a transparent, independent, and also public investigation. We know it won't be transparent because the committee is legally bound to secrecy. It simply isn't authorized to be transparent. We know the inquiry won't be independent either because the Prime Minister personally chooses the rapporteur. So since we know the inquiry won't be transparent or independent, it obviously won't be public either. So what's the Prime Minister trying so hard to hide from the public? The Honourable Minister of Interparliamentary Affairs. Mr. Speaker, my honourable colleague is repeating things about a secret committee. That's a committee where the bloc has membership. The member from the bloc will hear all the high-level appropriate information and on this issue and other issues of national security, and the government will be sharing the reports of that committee. So this is a process that the bloc is a full participant in, among others. And this is not the only process that we've created to fight this threat.
Albert Edmonton.
Mr. Speaker, instead of following the advice of CSIS to provide transparency and sunlight when it comes to Beijing's election interference, the Prime Minister announced what amounts to a cover-up, a secret committee with secret evidence and secret conclusions redacted by the PMO, all to bury the truth. No transparency, no sunlight, total secrecy. What does the Prime Minister have to hide?
The Honourable Minister for Public Safety.
Mr. Speaker, honestly, I would have thought that my colleague was paying attention to the announcement yesterday when we said we would be appointing a special rapporteur who would possess the expertise and the knowledge to put forward a recommendation up to and including a public inquiry so that we could address the very serious allegations with regards to this matter. More importantly, this government has taken concrete action to combat foreign interference with the additional powers that we've given to our national security community, but with the additional transparency so that we can be upfront with Canadians. Mr. Speaker, the Conservatives continue to descend into partisanship. Our government is focused on protecting our institutions and Canadians.
The Honourable Member for St. Albert, Edmonton.
Mr. Speaker, what the Prime Minister announced yesterday is nothing more than a smokescreen with no transparency. Indeed, the only thing that is transparent is the transparent attempt by Liberals to cover up what this Prime Minister knows about Beijing's election interference. And consistent with this, today at committee, the Liberals are filibustering to block the Prime Minister's Chief of Staff from having to testify. Why? What is the Prime Minister so afraid of? What does he have to hide?
The Honourable Government House Leader.
Mr. Speaker, I have every reason to believe that the member opposite, for the entirety of his life, has fought for Canadian democracy. I would believe that he knows that I have done the same. I believe that he would know every member in this House has done the same. I believe that the member opposite would also know that foreign interference is a threat to our democracy, that the objective of any nation to interfere in our democracy is not a threat against a party or a government. It is a threat against our democracy, and that, Mr. Speaker, we are united in making sure that foreign interference is repelled. But, Mr. Speaker, national security cannot be played with. We need to deal carefully and delicately.
The honourable member for Kildonan St. Paul.
Mr. Speaker, the truth is the Prime Minister doesn't want accountability on Beijing's election interference that helped the Liberals win. He wants a secret committee with secret hearings and secret evidence and a secret conclusion, all controlled by the Prime Minister. Canadians deserve far better than this, Mr. Speaker. They deserve the truth. They deserve accountability. They deserve a true defense of our democracy. We need transparency from this government, and if they can't do it, then they should get out of the way, because Conservatives will get it done. When will they call a public inquiry, Mr. Speaker?
The Honourable Government House Leader.
Speaker, it is elections and democratic process that decides who gets out of the way, not members opposite. Secondly, Mr. Speaker, I would say that back when Justice O'Connor and Justice Iacobucci issued their reports talking about the need for parliamentarians to be able to see into every corner of government, it was the Conservatives that opposed that idea, that the secret committee that they're maligning and attacking is one of which their own members sit, where they are given the opportunity to see into every corner of government, where they're able to see every document that is protected by national security. I hope that the party opposite is not suggesting that we should say to our Five Eyes partners that all of our national security information should be put on display.
The honourable member for Leeds Grenville, Thousand Islands and Rideau Lakes.
The committee that these members sit on this side of the House are banned by the Liberals from talking about what takes place. Today, Speaker, I was at the Procedure and House Affairs Committee where the Liberals were engaged in one of their cover-up filibusters. So my question is to the chair of that committee to find out if she will resume the committee today at 3:30 so that there can be a vote on having the Prime Minister's Chief of Staff, Katie Telford, testify on what she knew and when she knew it about the foreign interference efforts. So if the chair won't stand, will the vice chair of the committee stand and tell us if that committee will resume today?
Okay. The honourable government. One moment. I want to make sure all the rules are followed exactly correctly. Okay. The honourable member for Perth Wellington.
Mr. Speaker, as Vice Chair of the committee, I can confirm that after 3 hours of Liberal filibustering this morning over calling Katie Telford to committee to answer about the Prime Minister's and what he knew about Beijing's interference, the Chair arbitrarily suspended the meeting. I am pleased to report that the three opposition parties have agreed to provide the resources necessary to resume this meeting and finish this Liberal filibuster today. Mr. Speaker, as Vice Chair of the committee, I am proud and able and willing to regavel the meeting to order at 3:30 if the member for Waterloo will not. Mr. Speaker, the question is, will the Liberals show up or continue the cover-up?
The honourable member for Courtenay Alberni.
Sishat First Nation has shared its partial research findings into the horrific deaths of children at the Alberni Indian Residential School, which operated on its
The honourable member for Courtenay Alberni from the top, please.
Mr. Speaker, Sashat First Nation has shared its partial research findings into the horrific deaths of children at the Alberni Indian Residential School, which operated on its lands without consent for almost 80 years. 17 suspected unmarked graves have been identified through ground-penetrating radar. The community also confirmed at least 67 students died while at the school. The nation has made calls for truth and justice, including funding to complete this research, removal of the remaining buildings, and replace it with a healing and cultural center. Will the Prime Minister honor the Sashat calls for truth and justice?
The Honourable Minister.
Thank you, Mr. Speaker. I want to thank the member for this important question, not only for all the survivors and families that were sent to this hideous institution, but also for the communities that are going through a lot of pain and trauma trying to come to grips with that grim reality. This continues to shock the conscience of Canadians, and I have spoken to Chief Counsellor Ken Watts on a number of occasions, indeed visited the community twice, and have undertaken to do all what we can on behalf of Canada to make sure that there is some measure of healing that is afforded to those survivors as well as to the community. Thank you.
The Honourable Member for London Fanshawe.
Canadian brewery workers are worried. Labour unions representing them, including Unifor and SEIU, are sounding the alarm because the federal government plans to increase beer taxes by 6.3% on April 1st. This would be the largest federal beer tax increase in the last 40 years, and it's happening with no debate in Parliament. Beer production costs are soaring and sales are declining. This tax will have a huge impact on jobs in Canada. Will this government help to protect brewery jobs by cancelling this unprecedented and automatic beer tax increase?
The Honourable Minister for Tourism.
Mr. Speaker, we understand the work that brewers do in this country, and whether it's small craft brewers or the large producers, this is an important industry for our tourism sector, but also for Canadians for recreational purposes. Mr. Speaker, we cannot comment on what's going to be in the budget. We have heard from the brewery industry, and we are taking this matter under advisement. Thank you, Mr. Speaker.
The Honourable Member for Yukon.
Mr. Speaker, the inherent rights of the Métis were confirmed in the Constitution Act of 1982, and 40 years ago today, the Métis National Council was officially formed. Since its inception, the MNC have been fierce advocates for Métis across Canada. Can the Minister of Northern Affairs please update this House on the federal government's partnership with the MNC and the important work we're doing together with Métis?
The Honourable Minister for Northern Affairs.
Thank you for that important question. I'd like to thank the member for Yukon for all of his hard work on all of these issues. I congratulate the Métis National Council for 40 years of hard work for the rights of Métis across the homeland, building on the legacy of our ancestors. And I commend Cassidy Caron for her stewardship of the Council, and I also commend and congratulate all of the previous presidents of the Métis National Council over the last 40 years. Our government is working hand in hand with MNC on issues such as reconciliation, housing, the environment. There's lots of work to do, Mr. Speaker, but we are making progress.
The Honourable Member for Calgary Forest Lawn.
8 years of Liberal failures, they continue to break records, just not ones many can celebrate. Not only are 1 in 5 Canadians skipping meals, but food bank usage is at a record high. A Mississauga food bank saw a 41% increase in usage, serving more than 13,000 people in January alone. That's the average attendance of an Ottawa Senators game. Why does the Prime Minister continue to brag and celebrate his failed policies that sent 1.5 million Canadians into a food bank? Or was that his plan all along?
The Honourable Minister for Tourism.
Mr. Speaker, we know that Canadians are going through a hard time. There's an inflationary cycle that has gripped the world. And the fact that in this country, Mr. Speaker, our inflation is lower than the average in the G7 and in the EU is not good enough for Canadians. And that's why we have a robust set of affordability measures in place, Mr. Speaker. The other side provides no hope, no plan, no vision for the future. We do. That's our job. We've got the backs of Canadians.
Honourable Member for Calgary Forest Lawn.
They got the back pockets of Canadians, and we would never ever vote for policies that made housing double. After 8 years of their failures, rents and mortgages have doubled since 2015. Random Liberal Bill Morneau said that this government overspent. That made the Bank of Canada jack up its rates to counter that. And now CIBC is saying 20% of its mortgages are at a point where monthly payments don't even cover interest anymore. So will the most expensive housing minister in Canada's history stop patting himself on the back for a job well failed and admit that he broke housing in this country?
The Honourable Minister for Sports.
néfaste, tout ce qui est arrivé au Canada.
There's everything that has happened in Canada and in the world these past few years, including the pandemic. What we need to remember is that this government has been there for those who needed help the most. It's also important to remember that after years of a Conservative government, when our government took office, we lifted 1 million Canadians out of poverty, and we also created more jobs over the past 10 years than were created during the Conservatives' time as government. So our government has done more for the people of Canada than the Conservatives have ever or will ever done.
Mr. Speaker, after 8 years of this Liberal Prime Minister, Canadians are struggling. Seniors are being pulled out of retirement and forced to re-enter the workforce in order to pay for food and housing costs. Grocery prices are out of control. The average rent for a two-bedroom apartment across Canadian cities is $2,000 per month, compared to $1,200 per month in 2015. Will this Prime Minister step aside and let the Conservatives fix what they've broken?
The Honourable Minister for Seniors.
It's really important to look at the facts. And the fact of the matter is, Mr. Speaker, when that party, the Conservative Party, was in power, their plan for seniors was to raise the age of retirement to 67. Mr. Speaker, first thing we did, we reversed that back to 65. We then enhanced the old age security. We then enhanced the guaranteed income supplement. Mr. Speaker, every step of the way, the party opposite has opposed measures to support Canadians and has stopped us from doing the work for seniors. We won't take any lessons from them, and we're going to continue to make sure we deliver for seniors. Thank you.
The Honourable Member for Charlesbourg, Haute-Saint-Charles. Mr. Speaker, this is the year that Canadians will feel the full impact of the Bank of Canada's 4.25% base rate hike. According to Statistics Canada, 35% of Canadian households reported that it had been difficult for them to meet their financial needs over the past 12 months. 44% of respondents expressed concern about their household's ability to buy a home or even pay the rent. Will the Prime Minister admit that his out-of-control spending has fueled inflation and created conditions that are impoverishing millions of Canadians? The Honourable Minister of Tourism. Mr. Speaker, we have implemented so many supports to help people get through the pandemic, and those supports did not create inflation. No matter what the Conservatives might say with far-fetched theories, they don't have a plan for the economy. They don't have a plan for housing. They don't have a plan for climate change. They don't even believe in climate change, Mr. Speaker. On this side of the floor, Mr. Speaker, we will continue to follow our plans and policies to help Canadians. The Honourable Member for Laurentides-Labelle. Mr. Speaker, the House Procedure Committee has voted in favour of an independent public inquiry chaired by a commissioner chosen with the agreement of all parties in this House. The Bloc, the NDP and the Conservatives were able to set partisanship aside because what is at stake here, Mr. Speaker, is the public's confidence in their electoral system. What's at stake here is not partisanship. Does the government really believe that it can restore public confidence with a secretive committee and a reporter who reports directly to the Prime Minister? The Honourable Minister of Interparliamentary Affairs. Mr. Speaker, as I said a few moments ago, we share the same concerns as our colleagues when it comes to strengthening our democratic institutions and strengthening them against foreign interference by countries including China. We have taken action. We have implemented many measures, Mr. Speaker, and we will continue to further strengthen our democratic institutions. That's exactly what Canadians expect of a responsible, transparent government like ours. The Honourable Member for Laurentides-Labelle. Mr. Speaker, in a democracy, people are not guaranteed to win elections, but elections do need to be conducted properly, without cheating, without money received on the sly, without voting under duress, and without foreign interference. That is what democracy is all about, Mr. Speaker. Those are the necessary conditions for us to accept the results of an election. If people lose trust in their electoral system, democracy itself is weakened. That is why we need a public and independent inquiry. Why is the Prime Minister stubbornly refusing this? The Honourable Minister of Public Safety. I share the concerns and worries of my honorable colleagues. This is why we set up an independent panel which verified that the two elections in 2019 and 2021 were fair and free elections. And we will follow up on this with a process which will be led by a special reporter. The reporter will table recommendations that the government will follow. Yes, I agree. This is all very important, and we will continue to protect our democratic institutions.
Okanagan Similkaming Nicola.
Mr. Speaker, CIBC is the first bank to show that on 20% of its mortgages, the monthly payment doesn't cover interest, increasing what the borrower owes on top of their original mortgage. Does the Minister of Finance agree that inevitably these higher debts must be paid down, something that borrowers can't afford now, let alone at higher costs later? And if she believes that's true, why does she continue to relentlessly borrow, and spend when it's not only inflationary, but a debt that Canadians cannot afford today, let alone tomorrow, Mr. Speaker?
The Honourable Minister.
Mr. Speaker, we are going to continue on our prudent fiscal track that we laid down in the fall economic statement and in Budget 2022. It's intriguing, Mr. Speaker, that the Conservatives are having a little laugh fest today because, Mr. Speaker, that's prudent.
The Honourable Minister from the top so we can hear the whole answer, please.
Mr. Speaker, perhaps we should go back to the past, Mr. Speaker, and talk about 9 years of stagflation during the Harper government when the Canadian economy didn't grow more than 1%, maybe 1.2%, and which country in the world is positioned to lead the G7, Mr. Speaker, in growth next year? Canada. Is that good enough for Canadians that are struggling with inflation? No. That's why we have affordability measures in place. They voted against them. We're voting with Canadians. They can hoo and haw. We're here for Canadians.
Honourable Member for Central Okanagan, Similkaming Nicola.
Mr. Speaker, Canadians aren't buying the house of debt that this minister's selling. So in Kelowna, we are now recognized as one of Canada's top 5 highest rents, and it shows. This Minister of Housing has failed to house the homeless on the streets of Kelowna. Now, with rentals and home prices doubling, there's no way that his policies can help them, let alone the middle class and those working to join it. Does this minister understand, Mr. Speaker, that he's failed the people of Kelowna? If so, will he move out of his office today to make room for someone else, or is he waiting for an eviction notice from the Prime Minister?
The Honourable Minister for Housing.
Mr. Speaker, it is really rich to hear rhetoric coming from the other side when they have voted against every single measure that we've put in place to help Canadian renters. When we put together the Canada Housing Benefit, they voted against it. When we introduced a $500 top-up payment that is going to almost 2 million Canadian renters, they not only voted against it, they played procedural games last fall in this House to delay payment that was going to almost 2 million Canadian renters to help them with the cost of rent. Canadians can see through their rhetoric, Mr. Speaker.
The Honourable Member for Bellechasse-les-Échemins-Lévis. Hello, Mr. Speaker. Mr. Speaker, after 8 years under this Prime Minister, home and housing prices have skyrocketed. Successive interest rate hikes have been a blow to homeowners. The average cost of a mortgage in Canada, Mr. Speaker, has more than doubled and now averages $3,000. So people can't access property, young adults are living in their parents' basements, and there are students living in shelters. When will this Prime Minister acknowledge the problems that he caused, show some compassion, and finally help Canadians? The Honourable Minister.
Help first-time home buyers access the dream of home ownership. We're building more supply by working with municipalities and provinces to get more barriers out of the way, to build more housing across the housing spectrum. What do? They vote against all these measures. In addition to that, it's been a year, more than a year, since their leader took helm of that leadership, and they don't have a housing plan. They don't have a plan in place. They don't have the voting record. When they were in government, they spent meager amounts of money, and every time that we bring measures in place to help Canadians across the housing spectrum, they vote against it. Canadians can see through that, Mr. Speaker.
The Honourable Member for Laval-les-Îles. Mr. Speaker, our government has made significant efforts to recognize historical wrongdoing and to recognize the criminalization of vulnerable communities throughout Canada. Today, as part of these ongoing efforts, The government has reaffirmed its commitment towards all women and all 2S LGBTQI+ communities by making several offences eligible for expungement. Can the Minister of Public Safety inform the House of the positive impact that this announcement will have on Canadians? Thank you, Mr. Speaker.
Ministre.
The Honourable Minister. Thank you, Mr. Speaker. I thank my colleague for his question. We must recognize the historical injustices that have historically targeted vulnerable communities. That is why I announced today that bawdy house, indecency, and abortion-related offences will be eligible for expungement. These offences have primarily affected women and members of the LGBTQI+ community. We need to also protect the right to choose and the right to safe sexual health services.
Bridge.
Bill C-11 is an unnecessary and grotesque overreach of government control. It censors what Canadians can see online, what they can post online, what they can hear online. The minister has said that this bill is about supporting Canadian culture, but that's actually not true. You see, the bill actually stifles creators. It stifles their voices. And in fact, subject matter experts have actually said that it likens Canada to countries like China or North Korea. So will the Prime Minister stop this damning overreach and kill Bill C-11?
The Honourable Minister for Canadian Heritage.
Well, Mr. Speaker, the Conservatives had an option. They could side with Canadians, they could side with our music creators, with our film producers, with our actors, but they decided to side with the tech giants, abandoning the cultural sector.
That's
Mr.
terrible.
Speaker. And that's a shame in itself. There's another thing, Mr. Speaker. I don't think they understand the bill. I'm not even sure they read it at this moment.
I don't think they
year
did.
after, because if you read the bill, it's very clear. It's simply asking the streamers to support our culture. They understand that. Everybody understands that, but the Conservatives.
Member for Lethbridge.
I would invite the member opposite to listen to Canadians. When they came to the House of Commons and when they came to the Senate, they said the same thing over and over and over again. Creators, content experts, and Canadians at large do not want this bill. It stifles their voice, it prevents Canadian culture from being furthered, and it likens us to places like North Korea and China. It's a terrible bill. It needs to be killed. Will the minister concede to Canadian voices, give them the power, and stop this terrible legislation?
The Honourable Minister.
Well, we have to give it to my colleague. She's very creative, which is very good in the cultural world. But if you listen to the people in the music sector, in the film industry, the music industry, they're all behind this.
Yes.
Why? Because it's asking streamers that make a lot of money. It's fine. We're happy for them. It's just asking the streamers and Netflix, this of this world, to contribute to the creation of more music from here, for more films, for more television. It's good for Canadians, not for the Conservatives. Good for Canadians.
L'honorable député.
The Honourable Member for Louis Saint Laurent. Mr. Speaker, the Liberal government likes to be in control, and they showed us that once again yesterday when they created a secret committee with secret hearings and secret evidence, secret conclusions. That is total Liberal control. But that's what motivates this government. That's what motivates them with the CRTC Act that they want to amend. But you know what this government can't control? The province of Quebec's will to be heard. Quebec wants to be heard. When will the Liberal government convene the committee so that Quebec can explain its stance? The Honourable Heritage Minister. Mr. Speaker, my colleague is from the same province as me. We're both Quebecois. I don't know if he's spoken to the La Disque Federation, but La Disque supports our bill, and the Union of Artists also supports our bill. Music producers, film producers, TV and movie producers support our bill. There's a lot of support for our bill. Why, Mr. Speaker? Because it's good for Quebec's culture. It's good for Canada's culture. The Conservatives don't like it because they don't care about culture, but we care about culture. We stand up for it, and we always will, Mr. Speaker.
East.
Mr. Speaker, seniors around the world and in Canada were some of the hardest hit by the pandemic. Conscious of the lessons we've learned from the pandemic and given Canada's rapidly aging population, can the Minister of Seniors please update this House on the work that she is doing with Canada's international partners to advance the rights and interests of older individuals, both here at home and abroad.
The Honourable Minister for Seniors.
Mr. Speaker, I want to thank my colleague from St. John East for that important question and her for ongoing advocacy for seniors. Mr. Speaker, I'm happy to inform this House that Canada this week joined the UN Open-Ended Working Group on Aging. Canada will be using this opportunity to advance seniors' human rights and efforts to support seniors around the world. Canada is a global leader in supporting seniors with a robust pension plan and universal healthcare system, and we look forward to sharing our experience and work collaboratively to improve the lives of seniors both here and around the world. Thank you, Mr. Speaker.
The Honourable Member for Skeena-Bulkley Valley.
Mr. Speaker, Prince Rupert is home to one of North America's fastest growing ports, but the city of Prince Rupert is struggling to maintain the basic infrastructure needed for a growing workforce. In December, the city declared a local state of emergency after several water main breaks, and now city officials fear the catastrophic failure of the city's water infrastructure. Now, the BC government has pledged support already, and it's written to this Minister of Infrastructure and asked for federal help. Why won't this Liberal government step up and help this city in crisis?
The Honourable Minister for Interparliamentary Affairs.
Mr. Speaker, I want to thank our honourable colleague for raising that important question. He and I have had a number of productive conversations about this important project. Officials of my department have spoken with the city as well. We understand that his point is very accurate. This is a critical piece of Canada's economic infrastructure, and yet a municipal water system is dependent on a community with a population that is necessarily much more limited than the economic impact of the larger port and its infrastructure. I've had conversations with the government of British Columbia in this regard, and we hope to have good news soon.
Honourable Member for North Island, Powell River.
Mr. Speaker, for decades, women in the RCMP suffered a shocking amount of sexual harassment and discrimination. Now Veterans Affairs is clawing back their disability pensions. Months ago, following the Merlo-Davidson lawsuit, the Ombuds recommended the clawbacks stop. But the minister has done nothing. He is making these women who served their country suffer all over again. When will he fix this and make this right?
Here, here.
The Minister for Veterans Affairs.
Thank you very much, Mr. Speaker, and I appreciate my honourable colleague's concern, and I also appreciate the Ombudsman and her office for providing recommendations to the government. The women who came forward and disclosed their experience in the Merlo-Davidson did so with incredible courage. We will have more to say on the recommendations made by the Ombuds shortly, and thank her on behalf of the veterans and their families. Thank you, Mr. Speaker.
Good job. I'm afraid that's all the time we have. C'est tout le temps que nous avons. It being 3:20 p.m., pursuant to order made on Monday, March 6, 2023, this House stands adjourned until tomorrow at 2 p.m., pursuant to Standing Order 24-1.